Just directly east of your property, and I'm kidding on the grade, Rambler, common to the tennis court. Pleasure meeting. Pleasure meeting with you. This is not personal, it's just about business.
Good morning. I call this session of the City of Kenmore Land Use Hearing Examiner to order. I'm Ted Hutter, Sound Law Center, who is chosen by the Mayor and Council to hear and decide certain land use applications and appeals. This morning we're here because of an appeal that was filed by 4 individuals, and Mr. Matt Crawford has been chosen as the spokesperson for the appellants. Mr. Crawford, present. Who's Mr.
Yes. Doesn't the light come on this thing?
If the button is up, it is on.
Okay.
Okay. So where is the
Matt
appellant?
Crawford is present.
All right. Good morning.
Good morning.
You ready to proceed today, are you? Okay. And also involves the city. I think the city staff is here at this table. Okay.
Correct. I'm Samantha Loyick, Assistant Planner for City of Kenmore.
Very good. And then you would be the applicant?
Kip Shepard, applicant.
So an appeal of a city decision, in this case it's an appeal of a threshold determination. Threshold determination is made following an environmental review of an application, and the city has the responsibility to conduct that in accordance with its own ordinances, as well as the revised Code of Washington, Chapter 4321C. So the purpose of this open record appeal is to allow the appellant to present information to me about where they believe the city erred in not conducting environmental review properly, where the city should have done something differently. I think the issue raised in this appeal has to do with concerns about stormwater and its impacts on surrounding properties. I think that's our focus today. And the way we proceed is to allow the appellant to call witnesses and present documents to me, and I appreciate that you did provide those in advance of the hearing. The idea there is that there's no surprises at the hearing, that the exhibits have all been numbered and placed in this notebook. You each should have the exhibits that the others intend to present, and as well as a list of witnesses that you might call this morning. So the first order of business is to allow the appellant to present witnesses and point to the exhibits you believe are relevant that I should consider when making a decision. We then allow both the city, who's been alleged of not doing work properly, and the applicant, who's impacted by the decision, to respond to the appeal. During the course of the hearing, witnesses that you present are available or will be made available for questions asked by the city or by the applicant. In the same way, if the city presents witnesses, you will have, as the appellant, an opportunity to ask questions of that witness. It's my responsibility to listen closely, to ask clarifying questions when I need to understand something more closely, and then to issue a decision based on only what's presented in this hearing room today. This hearing is what is known as a record hearing. It is the only opportunity to present information. If there's an appeal of a decision that I make, it's based only on the record, which are copies of the exhibits that are admitted and a transcription of any testimony that's presented. A word about the exhibits. In this hearing examiner proceeding, any exhibits that have been identified prior to the hearing are deemed admitted into the record unless I hear an objection during the course of the hearing. So that's how we'll proceed. Are there any preliminary matters before we allow the appellant to present information?
I have a preliminary matter.
This is Mr. Kip Shepard?
Yes, that's correct. I have the tracking for the certified mail of sending the exhibit lists and the documents themselves, and the applicant, we did not receive the documents from the appellant until October 14th at 3:48 p.m. They weren't mailed till a day after the deadline.
Okay, and that's information you're
Can I
providing.
make a motion to have this entire appeal dismissed based on that?
Oh, I see. So you got exhibits 2 days ago.
That's correct. And the appellant received theirs a full week in advance as what the pre-hearing order requested.
Well, Mr. Shepard, you've had an opportunity to review the exhibits. Do you feel that you need additional time?
I feel that it is difficult to get a bunch of professionals in one place, and we don't want to reschedule the hearing, but it would have been nice if the appellant could have followed the procedures and had, stuff to us as we did to them, giving them a full week to review our materials.
Okay, we'll allow the appellant to respond to that objection before I rule on it. Mr. Crawford, do you have any response to what Mr. Shepard is objecting to?
He's described the situation exactly, and from an oversight on our understanding in that throughout our concerns since 2009, we have dealt only with city planners, and our communication's been through them. The procedural instructions on a couple initiate that you do communications through the city, and it was an omission, not an intent to delay any discovery by them, and fully appreciate their concern or lack of time to evaluate any of our concerns, although we have a history, like I say, since 2009, and have been communicating with the same concerns with the planning department on the proposed mitigation of the stormwater, and that there is some mitigating circumstance that precludes this application, in that it was known to this proposed buyer and this situation that a material problem with the property was in question. But to be more specific, I fully appreciate, we all understand that was an omission, unintended, but nonetheless.
Okay, thank you. Your motion is to dismiss the appeal because you received exhibits later than anticipated and later than was identified in the pre-hearing order. Is that correct?
That's correct.
Okay. I'm not going to dismiss the appeal. It's actually a courtesy. I do, as part of my management of an appeal, provide a pre-hearing order. That's not typical in many jurisdictions. You don't get that opportunity. And you only see witnesses at the hearing itself and identify documents at the hearing itself. So I do find that your concern is warranted, and what I will do through the course of the hearing is allow you, Mr. Shepard, an opportunity to review a document more closely if you feel you haven't had that time to do before the hearing. And we can accommodate that through the course of the hearing by you just indicating to me, I haven't had time to review this document, or my witness needs to look this through before he can testify about it. And we can take that time to do so. And I'm making that ruling, too, in part because I don't find the documents overwhelming in detail. I think they're fairly comprehensible within a short period of time. So the appeal will go forward, and recognition that during the course of the appeal, Mr. Shepard may ask for time to review a document. Would you get these for me? What I'm going to circulate to each of you, and thank you, Samantha, for helping, is a copy of the witness and document list that you each submitted in advance of the hearing. This is just to help us during the course of the hearing to make sure we're referring to the correct documents. There's nothing new on that. It's just putting everything in one place so we know what documents each of you submitted and what witnesses each of you called. Any other matters to bring to my attention before we get into the appeal?
Mr.
Crawford.
If I may, and give you a copy, because of the unsophisticated level, I would throw the discretion for you to submit a more descriptive explanation of our short survey check, and that it would, in other words, just giving raw numbers to a layman is a little confusing, but at least to be able to examine one reference to an exhibit to be more clear to the point as far as explanation. And I'd like to hand a copy of those out at this time, if that's okay.
I'm not sure what this is about, but do you have a witness that will be testifying about this document?
We will be referencing an exhibit, and
Okay,
in that,
why don't you present it at that time so we have the right context
Yes,
for
sir.
it? All right.
I have one further question is,
Shepherd.
my witness list lists Bob Pust as the property owner, which is the case, but I'm wondering if I can have his wife Judy as the witness instead.
Oh, because Mr. Pust is not available?
No,
today?
he's here, but in talking with Judy this morning, she told me some things that I think would be more relevant to a call as a witness.
Okay, is there any objection to that by the appellant? No. All right, sounds appropriate. All right, then we turn to the appellant, Representative Mark Crawford. And what can happen if you want to, it's up to you, is sometimes what's called an opening statement, or give me an idea of what your appeal's about, and then you can call a witness, and we will have the witness here, and they are sworn in and then provide testimony. You can consult if you need to.
Just a general question for our edification. I'm assuming that all parties have read our initial appeal document, and is that correct?
I would say you don't make any assumptions about who's read what. So if there's an issue you want brought to my attention, it's best to identify that by reference to the document or speaking directly to it.
Okay.
And who is the speaker now?
Good morning, everyone. Good morning, everyone. My name is Brian Rice, residents of 16947 84th Avenue Northeast.
And do you expect to be testifying now? Are you the witness that's called by the appellant?
I'm the witness on behalf of the appeal.
Okay. Mr. Brian Rice would like to testify.
Make the opening statement.
My intent here is to make the opening statement.
Okay. And you will be a witness during this proceeding?
Yes.
I'd like to ask you to take the oath then, if you'd please raise your right hand. And do you swear to tell truth and testimony you give today?
I do.
Thank you. Mr. Brian Rice.
Again, my name is Brian Rice. I'm resident of 16947 84th Avenue Northeast, adjoining property to the noted appeal. The reason why we're gathered here today is all about water mitigation coming off of the noted properties. The area that we're talking about here has a large amount of surface water that comes off of the hill. Adjoining properties have been flooded and mudslides in the past years. I've been there for 30 years and witnessed it all. The fact of the matter is about 50% of the noted plot of the area that we're talking about will be no longer able to take surface water into the soil and will have to be mitigated somehow. That water will end up going on the adjacent properties due to the fact that the design water mitigation plan is not adequate in order to consume all of that water runoff. So we're concerned about our properties being flooded. There is no plans in place for the design to take the water from the noted property into the Sammamish Slough and/or any other locations. The design advocates that all of the surface water will be put into a retention pond. And what I'd like to do is bring forth an exhibit.
We're not going to accept the statement.
Hang on a second here. Exhibit Boy 6, B6. It was dated January 12th, 2010 by LIU and Associates.
Okay, I have that in front of me.
Do you have that in front of you?
Yes.
Okay, under the geologic hazard, states based on the subsurface conditions per field investigation by AESI, the entire site was determined to be in both a landslide hazard and erosion hazard area. Additionally,
What page are you referencing?
page 5. Again, dated 2009. Excuse me, 2010, January 12, 2010. Additionally, on page 6, under conclusion and recommendations, under the general statement, says, therefore, it is our opinion that the subsurface condition of the site is not capable of supporting on-site infiltration systems to dispose stormwater into the ground by infiltration for the development of proposed residence. In summary, the soil does not have the capability to absorb the surface water runoff. That's it for opening statement. I will hand it over to Matt Crawford, and he will push his way through the exhibits.
Can we get a clarification where that's located? I'm having difficulty locating that text.
Oh, it's pages 5 and 6, and referencing a paragraph that's under the heading Geologic Hazards on page 5, and under Conclusions and Recommendations on page 6, the second sentence of the first full paragraph. Okay, so you've framed the scope of the hearing. It's really all about the water and the water runoff and whether it will infiltrate on the site or not.
Is, can I,
Mr. Shepard?
is it appropriate to question the opening statement?
No,
Okay.
because I think what's going to happen next, it's up to Mr. Crawford, but I assume you're now going to give some more support for that opening statement.
Reiteration, but just add, again, that just to review that our assessment of land use laws originate from common law, and that our land use rules center back to the Corps of Engineers, which is again based on common law.
Okay, and before you testify as to any facts, I'd like you to take the oath, if you would, please.
Oh, I would, by all means.
Yeah, and do you swear to tell truth in the testimony you give today?
Absolutely.
Thank you.
My
So
name is
you're-
Matt. My name is Matt Crawford. I live at 16941 84th Avenue Northeast, here in Kenmore. Yes, sir. I will. Basically, I wanted to just reference one CFR from the Environmental Protection Agency, and it basically references our approach as to how we view this problem. The cumulative, and I'm speaking, referencing 40 CFR dash 1508-8 line B, and in that statute, I will read it. Cumulative impacts are impacts that result from the incremental impact of the action when considered in light of other past, present, reasonably foreseeable actions. And the consideration of the cumulative impacts allows for mitigation programs to take into account these impacts individually, but be minor over the time and in concert with other activities may be significant. In saying that, our list of exhibits goes, and I'm not sure that it will be necessary to go through all of them, but to substantiate Mr. Rice's comment about the subsoil conditions, if you look at, let's see, well, E1, a letter dated 2000, anyway, E1 is close enough. At the bottom of the page, item 6, erosion control measures shall be provided in accordance with the design manual and the standards. And as at first appearance, it would appear that they are, but as they're proposed. But at a postscript, I noticed that the proposed site drainage design depicted in sheet C2 differs from the recommended design provided by the Louis and Associates geotechnical report dated January 12, 2010. And it goes on to say that you will verify this. This is an example of past problems with the design in that this isn't, we're revisiting an old issue. That being said, we could go to a letter E2, an example from Andrew Bauer to Thomas Tobin. And if we go down to the bottom, 3/4 of the way down the page, he references the report presents recommendations for the stormwater management practices that are in accordance with the King County, but we take no exception to this information, but there are no remaining unresolved issues in this as a hazardous area on that basis. But we contend that that conclusion at that time was incorrect, and it was later deemed also significant in that Andrew Bauer suspected, or at least stated to me at the time, and I guess this is going to be hearsay because he's of course not here, that we discussed the issue of the fill and the design of a dam in the ravine, or at least the swale of the natural drainage system, and that would, from a layman's point of view, be pushing water off to the side, the hydraulic action, or lack thereof, as acknowledged by the geotechnical report, that the water would flow into adjoining properties. Okay. At this time, I guess I would ask for guidance as to the period in time you want or feels necessary for us to present all of this information now, or do you want us to summarize things and revisit these exhibits? I don't want to belabor our points.
Well, it's your appeal, and the appeal is a serious matter. It does take time and attention to deal with an appeal. Your appeal alleged that the city made errors when it did its environmental review of this application for a reasonable use exception. And by the way, we're just here on that appeal of the environmental review. The permit is a matter that only the applicant can appeal. So you and your other appellants have appealed the environmental review. And I'm trying to track with you. Your last point was that this statement in Exhibit E2, which the city says we don't take any exception with the Liu report. And I'm trying to track what that means to you, because I understand that's the first report you presented, and it indicated that there was no ability for infiltration on the site. So you said you disagree with that city statement. Why is that?
The conflict, if you read in that reference, which let's revisit that.
Mr. Hearing Examiner, if I may, the E2 is not from Andrew Bauer. It's to Andrew Bauer.
Yeah.
Okay. So it was said it was from Andrew, and it's for an old reasonable use exception that is not the one that we have reviewed as part of the staff report. So this is a previous file number, and it's from Mr. Tom Tobin, geotechnical engineer.
So the city is objecting to this exhibit is not relevant to this proceeding.
Correct.
Deals with a different reasonable use exception?
Correct.
All right. Well, please, when you see that, bring the objections to my attention the first time an exhibit is referenced. That's helpful so that we can deal with it early on.
And
so let's not deal with Exhibit 2 then, E2, because it sounds like it was a different.
Exhibit 1 is also the same.
If I may, it's the same property.
And also, it's referenced later as being revisited and referenced as a precursor. In other words, this study was done, and as recently as, and we'll let's go through it and find it so to satisfy. In other words, it was recertified upon a visual inspection, not retested, and that it was in the opinion, and tell me if I'm referencing something that you don't agree with. I don't mean to project, but I think we need to go and look at that statement.
Well, possibly. I'm dealing with an objection now, and your response is it references the same property. All right.
It not only references the same property, but it was a recertification by the engineer to a old report.
All right. I still have the question about E2 then, and we will let it in. It's part of the exhibit that is part of this record. What's the significance of it? I don't understand. What are you bringing to my attention? Certainly, E1, compliance with the stormwater manual, yes, that makes sense. E2, I believe that your testimony was that the city made a mistake in referring to the Liu report that you brought to my attention early on, B6. What's the significance of the city statement?
If I may, on the conclusions, it states there are no remaining unresolved issues that pertain to geologically hazard areas information on this project. On that basis, we recommend that the City of Kenmore approve this application. The statement, there are no remaining unresolved issues, our case is that the issue is there no water mitigation plan for the noted property. That is our point with E2.
Okay, thank you.
Okay, moving on to E3.
This is Mr. Rice speaking now.
Would you be interested in us taking time and referencing the recertification reference to that particular report and document date?
Well, I think you're going to get there. I'm here to listen to your appeal, and I don't want to do too much to guide your appeal because that'd be unfair to the applicant and the city. But what you've done is you've alleged the city made a mistake. And the mistake that references the State Environmental Policy Act is that either the city did not identify significant adverse impacts, that's the standard that we're looking at, that's the legal standard, You're asking me to find that the city did not identify significant adverse impacts through the environmental review process. And your secondary point is, had they done so, they would have or should have looked for mitigation measures. Isn't that the heart? Isn't that your case?
In essence, but to go further and to get to the bottom line, if you read the last line on our appeal, that was most illustratively stated by our only resident civil engineer, Mr. Yo Chang, behind me to my left. He stated our appeal basically is no additional storm water runoff to adjacent properties. And in that light, all properties in this area have like-in-kind mitigation in that, granted they're old, they've been there for a generation or two. Better or worse, the water goes into the slough. The city referenced through this process that we denied the original property owners access to our current infrastructure, which comprises of a PVC pipe running down and draining as much water as possible off the properties that are there. That system is maxed out, as are all the systems along the slough that are in the same proximity to the slough.
Okay, and if that's what you want to show today, then yes, go through your exhibits and show me how that's true.
We are just saying that we ask them not to make an exception for one property and burden adjoining properties with additional runoff, in that they should be subject to the same like-in-kind systems, and there is an existing easement for a drain to be put in, but they've decided that, no, we can do this. But as our engineer has pointed out, the current design is if there's any excess water, it will go to adjoining properties. There's no other way.
This is the appeal where you have an opportunity to show that. I hear what you're saying, but you need to show why that's true.
Okay. Then we will reference that in a nutshell. We need to go to the reason that we were first flagged or interested in, we had questions, was the survey. And this goes back to 2009. It's essentially the same survey. I just want to say that I would, by going directly to this point, are we precluded for entering any other exhibits? I'm assuming you've been able to look over them.
Matt, could I interject here to try and keep us focused, and then we'll go with that question as we progress. Is that okay?
Just
what they're looking for.
Why don't you choose one of you to present the appeal? I thought it was Mr. Crawford, but Mr. Rice, are you ready to present the appeal?
Well, I believe what you're asking of us is to push our way through the exhibits and state our case.
No, I'm allowing you a fair opportunity to make your case.
Right.
And you have to understand this is an open record hearing where you have the attention of the city and the applicant and myself as the decision maker, and I just don't come in here saying, well, I know how to decide it. You have to present evidence in support of your appeal. I know you want something different, but it's different than the city and different than the applicant. It is your opportunity to present an appeal. I'm trying to provide a fair forum and an open opportunity to do that, but you can't keep asking me, what do you want me to do next? You need to present your appeal. Now's your opportunity.
Okay. Like Mr. Rice has suggested, if we go then to E3, and this is a letter again from 2010, and this what was given to me by, or at least forwarded to me by Andrew Bauer, and again it references our concern over the design and the drainage problem on the existing property. Again, we can revisit it if need be.
Mr. Examiner, I'd like to note again that E3 is for a different project. That's not the project that is being appealed now. This is an old memo that references different plans submitted at a different time years ago.
Thank you, and noted, we're still talking about the same property that has not been altered. Can we move to exhibit?
Well, the city is making an objection to exhibits, and let's get on the right path. Okay, we're off to a stumbling start. I don't think we've lost our way entirely, but we do need to be on the same path if we're going to get through this appeal today. And I'd like to get through it in the morning, if possible. So we need to get a little bit smoother in your presentation. So you've apparently submitted a number of documents that aren't related to this reasonable use exception. Is that true? We've had 2 city objections to E2 and E3. Are there others that relate to another application?
In that, I think we need to visit.
That's a simple question I'm asking. Are there other documents? This application, 2015, your document here, E2 and E3 are 2010. You know, right there, it's a question about the relevance. And I don't want to explore the differences between the 2 applications.
Absolutely, and that's understandable. And the tie-in would be the date of the GEO report that we referenced earlier, and there was some question as its validity as reference. And
then why don't you rely on that report?
I would like to reference it. So
nobody objected to B6. All right, is that
Yes.
the report you're talking about?
Yes.
All right, we'll look at that then. And I don't want to get into, well, it's the same property, but the project was different, and it's not helping.
No, I understand.
Okay,
I
so
can
why
understand
don't
the
we
confusion.
stop that path and get on the path of what's happened with reference to this proposal this year and how that affects the surface water. And a past project may have all sorts of differences in terms of how it was to be developed. And getting into those details, I don't think is going to be instructive unless you persist in doing that.
No, I absolutely understand where
All right.
you're coming from. I was just trying to clarify
Okay.
the relationship with an initial GEO report that has been recertified.
And that's
submitted.
B6. That's what you're talking about?
Yes.
The Lou report?
Yes, sir.
All right, that's in front of me. I've got that. You gave me the quotes out of that report. I'm not going to look further at E3.
That's fine.
And
That's fine.
and E2 as well,
Okay.
because they don't relate to this property, and the city's comment or the consultant's comment on those, it's not relevant. Looks like you're going to get into documents that are relevant to this action by the city referencing this application. Is that where you're going to go next?
In the sense that the acknowledgement and the use of a GEO report that was done in prior years, and the reference property in that to decline the realization of the information that other assessments were made by qualified engineers would, I'm sorry, I guess I don't understand that. You mean we can't reference?
I've made myself clear. You've introduced a report called the Lou Report. It's Exhibit B6, correct?
Yes, sir.
I've accepted that report. It's in evidence. I don't need some kind of recertification. It's in evidence with reference to this
I'm
property.
sorry, I misunderstood.
All right,
I
let's move
apologize.
forward, please.
Yes, sir.
Let's move a little more rapidly. I'm capable of listening closely, even if there's a rapid movement on your part. So
I understand.
let's move forward.
Well, then we want to omit or, well, anyway, E4 just again references past interest in the property, and that this was a continuing conversation that we've had concerning this property and our concern.
Okay, and we're not focused on that. We're focused on what's happened this year.
Yes. Okay. We can jump down to our, the E5 is our a letter that we reference to the city, or actually Mr. Rice has. And
okay, and that's dated this year. And I can make a finding that you and your fellow appellants have been concerned about this issue for several years. That's what you're trying to show me.
yes, sir.
All right, that's
a done
simple.
deal.
Then that might help you. You can let me know what you would like me to find, and I can find that you have been involved in this issue for several years. All right?
Appreciated, sir.
Okay, that's all we need to do on that. So now we're at E5, and you have something to tell me about that.
Well, again, that just we felt that it expressed our concern that the mitigation would lower the impact level to a non-significant level, and we felt that that was untrue, and that any additional water to the adjoining properties would be detrimental and overstress our water systems. E6 is a group letter after we John Harley has probably one of the largest properties in this area and is arguably covered by more buildings and play courts and whatnot than everybody else. But it was, again, just another involvement showing our concern about the existing water conditions. E8 is just an example to show that we didn't just have a question about concerning a survey, that there was an anomaly that was apparent to us that raised questions as to the validity of the design and the consideration of the topography of the site.
What is E8? I have it as an email from United Rentals. It's an invoice.
Pardon me, sir?
E8 is an invoice from United Rentals?
Yes. Yeah.
What does that show me?
It showed that we rented a piece of equipment to do a survey that was certified. In other words, the equipment was calibrated.
Okay, I'm going to try to help you. You've got a lot of documents, apparently, that, I don't mean to minimize your interest. It's clearly deep and passionate about the property, and you're concerned about what might happen with surface water runoff. I do want to focus you on, it is this project that I'm concerned about.
Absolutely.
I'm going to make a finding that you've had a long-standing interest and concern about surface water runoff from this property, and I'm referencing, for that purpose alone, E2, E3, E4, E5, E6, E8, a lot of documents about you've had a concern about this property for many years. All right, and that's fine. That's not what this appeal is about.
Understood.
So we're going to make that finding,
Yes.
and now we want to move to the documents that demonstrate
Absolutely.
your allegation that there is a problem with surface water runoff.
Absolutely, sir.
So we've dealt with the history. Now let's get to today and why you're alleging that this is going to be a significant adverse impact that the city should have identified and then should have mitigated. That is your case.
We could have included, let's say, E8 in E9 or we could have included it in E15. And actually, that would have been more appropriate. And I apologize for the...
Okay, let's just move forward.
Yes, sir.
What documents or testimony do you want to provide that show that there would be a significant adverse impact from surface water runoff that, according to your appeal, should have been mitigated by the city?
Yes. We reference E9, and again, this information brought to light after looking at the appropriate documents and referencing that there is a situation that shows that this property, with its slope, its impermeability to the ground, versus in reading and acknowledging the geo report from, we have water runoff problem. Enough on that.
What is it in E9 that relates to this property and shows that there would be adverse environmental impacts from water runoff?
There is reference in the city's documentation of that this whole area could be construed as a landslide and a erosion hazard area, and that E9, if you study it, will explain that.
Well, no, it's up to you to show me what's significant about it. It's a copy of a King County ordinance, is that correct?
Yes.
And
well, anyway,
what do you want me to do with that? How does it relate? You just need to show me.
At this time, I will table it to come back to it if it need be.
Okay.
Again, for our reference, E10 is an example of illustrating the apparent effects on the particular site. It references, unless you want me to go read it, it references a slope. It references a lichen type of silty soil. It's a landslide area. It's been recognized that by both the city and their geologists.
Are these pages from a report?
Pardon me?
What is this copied from? What is it?
E10?
Is it a report?
This is a landslide hazard areas handout from King County. I can read it into record, but I'm trying to expedite.
No, I'm not asking you to read it into the record, but I'm asking how it's related to this appeal. What is significant about it that you want me to pay attention to?
The slopes more than 40% grade. It references slopes more than or less than 40%, buffers and setbacks, the development standards, the allowed alterations.
Well, I can see what the report does. How does it relate to your appeal? What is it about this? First of all, what is the source? Can you tell me what you copied this from? The handout. It's a King County handout. Is that right?
It's a King. You can get it off of the King County website, as far as guidance goes.
And when you saw this, what did you think? How this related to your appeal?
It cites the landslide hazard areas and the critical considerations that or flags to call more scrutinizing your design and the potential for problems down the road, even though that you exhibit or try to install your appropriate mitigation measures.
Okay.
But in the fact that it's a recognized erosion area, it's a recognized landslide area, it's not hard for, I don't mean to insult the court or anyone else, but to assume that if the subterranean ground is supposed to support or sustain a containment area, and if it moves, then that containment area is going to be compromised. Enough said.
Okay.
Mr. Hearing Examiner, before we move on to the next exhibit, we would like to point out that E9 and E10 are referencing old King County codes, which are not relevant to this particular review.
All right. The city is making a point. Mr. Richardson, is it?
Yes, sir.
I didn't hear that as objecting to this being in the record, so they can be in the record. Their point is it's an older King County ordinance, but you just wanted me to look at these just to show, is this what you want me to show? A finding that if there's a landslide or an erosion hazard area, and this property is both, then extra caution is necessary and additional scrutiny is necessary.
Exactly. And in consideration of that many of the publications that are online are for potential buyers and or developers to consider when they're going to build on a particular piece of property. We are not trying to present a absolute expert opinion as to scientific consideration, but as homeowners experiencing the conditions as they are, we recognize this and have to reference this as a published public document. These are the kinds of considerations that you may or may not be aware of.
All right. Well, here is the finding you'd like me to make. If a property is identified as a landslide and erosion hazard area, then additional caution is warranted when considering development of that property.
Absolutely.
All right. Well, I can let the documents in for that purpose. E9 and E10 support that finding.
So, E12. The E11, as the city has stated, they have an apparent objection for us referencing a old document.
Well, E11 is dated 2010.
Yes.
February.
Again, we would object to this one. It's referencing the old RUE from 2008 with different plan sets.
And we are not going to cite or specifically cite a proposed structure. Primarily, our reference of prior documents is the discussion of the existing topography and water flow, and that time does not change those considerations. And for our reference in having a history with it and with prior discussions, granted, this is a commingled situation, but we are not implying that the city has not done or tried to do their job as best they can. We're not saying that.
What is it about Exhibit E11 that you
yes,
think is important for me to consider? We really want to get into the heart of your case.
I'm sorry.
But what is it about that exhibit that you think is important for me to consider?
On line 5, at the footings and drains shall connect to a catch basin, an area, and go into a sump. And what they were referencing in there at that time was an existing drainage system. and that and it was not done at that time because our system is overmaxed. And it's just a reference to that, basically, that we wanted to show that we didn't accommodate them then because we were maxed. We're having trouble now accommodating the water that we have, and that it's just a reference that this has been a problem, and it's a continual problem. On E11, again, we reference a problem with an on-site mitigation system that was ultimately changed or relating to the problem of mitigating existing water conditions. Now we move to E12, and we get it's rather a large document, and we couldn't staple it all together. But if you could turn to chapter 1855-320 of the critical area ordinances for the city of Kenmore. We'd like you to reference A, and I don't want to delay the hearing's time by reading every one, but would it be appropriate just to list the letters that we would like to reference? Yes, sir.
Yes.
I acknowledge yes. A. 18-55-320 performance standards, A, and then under D, Class 2 and Class 3 wetlands, 1 through 6, really, but basically 1, 2, 3, and 5. And in that 5 references, or 3 references, it had. Will the mitigation have an adverse effects on drainage and stormwater detention capabilities, and that any additional runoff off the subject property onto adjoining properties will just add to the lack of capacity of the current drainage systems that the adjoining properties have right now. And that, again, it reiterates our concern that no additional water come off the subject property.
Are you confident that this section relates to your property you're concerned about? It references wetland. Is there a wetland area?
There is, sir.
Okay.
Yeah, there's a Class 2.
You've been referencing steep slopes and erosion, so that's why I was curious.
Granted, for example, in general terms, this has been the driest summer, one of the driest summers in the last 50 years. And the subject property was, at least 90% of it was green all year round, and that's great, but it's a wet area.
Okay.
In section F, wetland buffers, and on section 2, the measurements of the wetland buffers, in that the subject property is within basically a quarter mile, 1,200 feet of the Sammamish River proper. And again, the city has cited in their, section 2A, section 2B, And then if we can jump up to Chapter 18, 55.650. And this is again in the relates to the performance standards and special hazards. Subheading A that references erosion and landslide hazard areas and activities associated on those areas. 1, 2, 2A through C, 2A through C, and D, excuse me. For your reference or for the edification, referencing Section 3, but in specific, I read the design standards alterations in Section 4. Design standards and alterations within an erosion hazard area and landslide hazard area or buffer shall be designed to meet the following basic requirements to be demonstrated an alternative, blah, blah, blah. I can go on, but in specific, we go to, oh, bear with me. The structures and improvements shall be located to preserve the most critical portion of the site and its natural landforms and vegetation. Given that the alterations to the proposed drain site will adversely affect the proposed wetland, it's just, in other words, if you read their own statutes, they say you're not supposed to modify within the critical area, but in order to make their mitigation, they would be required to do that and to change the topsoil at least. And it's been cited by the subsoil conditions are impenetrable, or they won't absorb water, and that there's no other place, we contend that there's no other place for excess water to go except to adjoining properties, and that it's not consistent with other properties' mitigation standards, and that we use water systems that go into the slough. Uh, 3A, though, it just says that oh gosh, I apologize for the delay. The requirement for long-term slope stability shall exclude designs that require regular and periodic maintenance to maintain their level of function and the basic design standards. And the design that is proposed requires a bond for maintenance over the long term, which we all enjoy raking leaves, but we know the function of leaves over your rockery all of a sudden. Anyway, we could have, we'll go on to E13 and E14 are just simply our statements of appeal, and that I would request that you read one or the other, because they're essentially the same verbiage. E15 and E16 on 9/11, myself and Yo Chang procured survey equipment. Yo Chang is a licensed civil engineer. I have an extensive background in using survey instruments in my construction trade. I'm a union carpenter, not setting elevations, a relatively simple operation. But this is really first and foremost was one of the main considerations that brought questions into our mind into the feasibility and functionality of the proposed mitigation, in that the elevations didn't seem to reflect the property, and that over the years, conversations with the planning department, it was understood that there may be anomalies here. Now, I would, at this time, I think I mentioned it earlier, and especially to the applicant that didn't get our information in time to interpret it and might understand our reason for question. And not to go through all of the sites, but let's see. I wanted to just hand out or submit to the parties a site list, in that our initial appeal had a site shot list with Yo Chang's engineer stamp on it to certify that he took the shots and that a licensed engineer conducted this survey. Would anybody, or could I hand out the explanation in more descriptive terms of the evidence that was presented with the appeal?
Yes, the proper way to do that is we would mark it as an exhibit that you're now offering.
Oh, yes, sir.
So
what would that be?
Mark that as E17.
Okay.
And what is your description of it? How do you describe that document?
It's a copy of field notes taken on 9/11 during our survey check process.
Now we have a document E16, isn't that what that is?
That is, but this is a more descriptive explanation.
Okay. We give a chance then for the applicant representative and the city representative to look this over, and then they have an opportunity to object to it, and if there's no objection, it'll be part of the record.
Could I suggest a 5-minute adjournment at this time, or is that
let
inappropriate?
me deal with this document. You just circulated it. City have any objection to it? They have no objection.
No.
No objection. So we'll have this as part of the record. Okay? So you now have E17 in as part of this record.
Yes, sir. Yes, sir. And then we can move to E15.
The plot of survey shots taken on September 11th, 2015.
Yes, sir.
Mm-hmm.
That shot string was taken over a linear line over 120 feet. The primary flag to us was that the survey depicts the applicant's survey depicts that my yard has a 10-foot gradient difference between the back of the yard to my rockery. And if you go to there's a circle J in the midpoint of the page, and there's a triangle down at the bottom center of the page at a curve. If I can just show everybody, so they, right here, and this is J. That would be the back of a rockery. This is exhibit E15. E15. That's J. And they show gradient.
Looking for my map.
Okay.
There's a gradient that shows off the back of my yard of 30, and then to the top of a rockery, it shows 40. The flag was that my yard is flat. And our shot string shows this. If we reference W, R, S, and J, if you go to E17 and read, look at the shot string line. It's at the starts out shot list and then points, point R through J and K. If you go to the extreme right-hand side, you'll see that W through K are essentially flat from the reference point, which all surveys have been taken from, a base point elevation of 32.9 feet, and that is at the apex, basically in the center of the page, a base point elevation of 32.95. Basically, finding the height of instrument and doing the standard elevation practice is prescribed to certified technicians. Rarely have I worked with a licensed architect or licensed engineer, and that I fully want to express my confidence in bonding. I would personally bond our elevations, and that Mr. Yo Chang did a most excellent job. And we carried, we didn't round off. And all I'm saying is that this shows an anomaly. This flagged our concern about the diligence that that the plan has taken a comprehensive, correct view, and that because the survey seems to be now, this recently, in error, that this would involve a problem with setting elevations, making the...
Okay, I understand your point.
Okay.
Let me ask you a question about it. I don't, this is your exhibit E15, and it's a copy of some
shots
elevations. No, I'm talking about your starting point. It's from some other document showing elevations, and then you show your elevations. But what is the starting point? What is the document that you took that from? It's not identified on the exhibit.
Oh, E15s are, no, E16 are shots.
No, I understand that. I'm looking at E15. You have written in handwriting on a document that shows elevations and a I guess, a proposed location. What is that? What is that document?
This document,
Yeah. What is that? What's that a copy of?
E15. E15 is a copy of the submitted plan for the subject property concerning RU 2015, RU 047.
And what sheet of that plan? Is it something we have in front of us?
Yes, we do.
You see, when you're in a forum like this, it's
I'm
somewhat
sorry.
formal, but the important thing is that any evidence I rely upon has to be really brought to my attention that it's an appropriate document.
I
And
appreciate
I'm trying
that.
to be patient and not looking at any rules of evidence. I understand you're not an attorney and apparently did not consult one to help you prepare the appeal. But one fundamental rule in an evidentiary hearing like this is that we need to be certain that what we're relying upon is, in fact, what it claims to be. Here with E15, I'm just asking, what is it? And you answered, it's a copy of the plan submitted by applicant. Well, there's lots of pages of a plan submitted by applicant, and sometimes there's more than one submittal, and sometimes they have different dates. So that's what I want to go to, is to see what you copied this from.
It is a copy of the advertised proposal for any.
From the notice of application?
Yes, it was, sir.
Okay. That's helpful for me to know. Thank you.
I apologize.
Well, you don't have to apologize. I'm just looking for answers, and you answered it. It's from the notice of application.
Yes, sir.
Not taken from the plan itself, but what the city reduced and then sent out as a notice of application.
Yes.
Okay. And I think we do have a copy of that notice of application somewhere. Did the city submit that as one of their exhibits?
Yes.
Yes.
C23, is that the right one?
Exhibit C5 is a very good copy.
C22 is a copy of the notice of application and site plan on the back.
Okay. And I just want to quickly check. Right. But the statement was taking it from that notice of application, and here it is in C22. Okay, so that's where you took that from. All right, and your point with showing me that is that you are questioning the accuracy of the submittal by the applicant based on that. Your yard, it was shown to have a 10-foot slope from one point to another point. I'm not sure it's your backyard. From house to rockery, is that it? But in fact, it's, according to you, flat. So that gave you a concern about the accuracy. Is that right?
Yes, sir.
Okay. And how does that impact your concern today? If it shows a slope and doesn't show flat, wouldn't that be of greater concern as far as water runoff?
In the sense, no, in direct relationship to the proposed construction, the change in elevation or the the lack of elevation, if the land profile is lower than existing on the profile, then we actually have more a steeper slope and or a lower point of drainage.
Okay.
It just raised our concern as to the overall completeness of the plan in this most sensitive area.
Mm-hmm. Okay, thank you. Well, you've had an opportunity. You've gone through each exhibit. Thank you for doing that. Is there anything else you wanted to offer in support of your appeal?
Just that we aren't asking for any special consideration other than to recognize the uniqueness of the neighborhood and to appreciate that residents in that neighborhood would like to see like and kind mediation, and that the excess water is not, it's a concern. But we appreciate the opportunity to present this, and again, we want to apologize to the applicant for our oversight in getting them pertinent information.
We've already dealt with that. It's
Yes, sir.
fine. I'm confused a bit. You say you want mediation. Do you mean mitigation of impact?
Yes, sir.
Okay, and what specifically do you think the city should have done? Or should do now?
All properties right now have systems that ultimately drain, for better or for worse, into the Sammamish River.
You say all systems in the immediate vicinity? Is that what you mean?
Yes, and public systems from other developments. Eventually, stormwater reaches its lowest point. But homes built over the years have gotten together and put in systems. Whether they were legal at the time may be a question, but nonetheless, that's what is now. But that cures the situation. As far as what can you ask anybody to do more than take care of their own and work with their neighbor to facilitate water removal in a proper fashion and not.
Okay, and that's a conceptual approach. That maybe is what a goal would be, but what
Okay,
specifically
in specific,
would you want to see done differently?
Yeah, I'm sorry, I didn't mean to interrupt. In specific, there appears to be we've discussed, and we haven't verified this, that there's an easement along an adjoining property line, an eastern section, to the slough that I guess currently right now is not being utilized.
You would like the city to require that the applicant utilize an easement? And for what purpose?
To propose a fix, I'm saying it's an option. It seems like the only obvious option that all the rest of the properties have done de facto. And when this property was sold, I'm assuming, well, everybody's dealing with water. How do you mitigate it? Well, you better have a way to get it to the slough. But now, of course, times have changed and requirements are different. I hope.
Okay, but we're focusing here
Yes.
on
Mr.
what you have brought as an appeal, where you said the city made errors. They didn't identify the extent of the surface water, and then you're asking that they require additional mitigation. And I'm asking what that is. What I've heard you say is that you would like the city to require the applicant to utilize an easement in the area
Could we get
to move
clarification?
water directly to the Sammamish Slough? Is that
Apparently.
all right?
Can
Mr.
Do we have
Richardson?
sorry, yeah, this is Mr. Richardson. Do we have an exhibit that shows that existing easement? Is there any evidence of that that we can view?
And what we're moving into now, I think it's appropriate. I think you've completed your presentation, and the city now, through Mr. Richardson, has some questions asking about your presentation. And the first is, do you have a document that shows the existence of that easement?
We didn't presuppose a solution to the problem, and given time, I believe that we could explore getting a copy of that reference. I wasn't honestly prepared to give that document. I didn't know that we would reference that.
Well, the relief sought in your appeal is twofold. One is compliance with ordinances, and I think that's always important. That's why we have ordinances. There does need to be compliance. But the second is, in simple terms, no additional surface water discharge onto adjoining properties. And that is the goal, but there is an obligation on the part of appellant to identify what mitigation specifically would reach that goal. And your answer so far is to utilize an existing easement. We're at the point in the hearing where the city is now asking questions. It's called cross-examination. The city has that opportunity to ask for clarifying. And it's okay if you don't have it, but the city's just asked, is there a document that shows where that easement might be?
I believe there is.
Okay, but we don't have it here today. Do you have personal knowledge of an easement?
It's been discussed, and I could add, the property owner that has that easement on his property could more. Yo, would you like to reference this question? Are you aware of an easement on your eastern border? Yo has confirmed that he does have a drainage easement on the eastern portion of his property.
Okay, and do you want to bring him up as a witness then? Would the city like to?
By all means.
To inquire of this witness? I would. And you can sit here if you'd like, or either place. Okay, please be seated, and might move that microphone in front of you a bit. I'll ask that you take the oath. If you'd please raise your right hand. Do you swear to tell truth and testimony you give today?
Yes.
Thank you. Mr. Richardson, did you want to ask? And let's get your name on the record, please.
My name is Youwei Chan, Youweichang.
And the question before us is there an easement that could be utilized by the applicant for drainage purposes that you are aware of?
There is a existing drainage easement. If you look at this property description plan on the
What exhibit are we looking at?
Exhibit C-5.
Okay. And where is it on that document?
C5. There you go. The north, or my name's Matt Crawford. Are you referencing north or south? Is that what you were trying to discern?
Well, this plan didn't really show it, but you can see a dashed line between the property line there, and it has more accurate drawing somewhere.
This is the property line that he's discussing.
Right. But that easement now is covered by driveways. And and virtually you can hardly access to it.
Vegetation.
But it's like 6 feet between the property line to, there's a 6 feet easement along this east side property line. It's a drainage easement.
Going westward?
And
Going
Hold on.
north and the south.
6 foot east-west?
6 foot east-west. But that easement right now is higher than the adjacent properties. So all the water goes into the easement, will drain into the adjacent property on the east side.
And is there any existing drainage system within the easement currently?
Yes.
Can you describe it?
It's under drain built by Mr. Rice.
So is it 4-inch, 6-inch?
8-inch plastic pipe.
And
30 years ago, I put in an 8-inch PVC along my property and into the slough, and that's what's there, and that supports my property, my house. And it also...
Okay, this is Mr. Rice responding. We're going to stick with one witness at a time. So is this the definitive witness? Mr. Rice has placed an 8-inch PVC pipe in the easement. We're calling it an easement. Is that...
No. Matt Crawford is speaking, and I wanted to define east-west property lines. There's a delineation between Mr. Rice and Mr. Chang's property line. The clarification that we've just been speaking about is the 6-foot easement that runs concert the eastern property line from Mr. Chang's property and Mr. Rice's property going north-south. From the eastern property line going west 6 feet onto Mr. Chang's property is the definitive drainage easement.
Okay, I've got that.
And what is the southern limit of that easement? Does it extend all the way to the subject property, or does Mr. Crawford's property have access to that easement?
It goes from the roadway all the way to the slough. The easement goes from the northeast 169th Street straight edge on the north side edge. Along that line goes through. It's 6 feet, go all the way through. It's a drainage easement.
You're saying there's an existing easement on the property we're discussing as well? In order to get up to the road, it would have to go through an adjacent property.
I remember that, yeah. It's
Okay, well, personal recollections, if there's to be a finding that an easement exists, it really does take a legal document describing the easement. And I guess we don't have that here. I can make a finding that there is a recollection or that there is some indication in the memory of those that own properties, but we don't have a document showing that easement. Is that correct?
That's correct. There is an ancient line that was dug by Mr. Rice from my northwestern property line to the slough, as far as my understanding goes. And then there was a pre-existing easement for a drain from any the subdivision of this subject property and Mr. Chang's property that run north-south, and they adjoin north-south. And that the current easement for that drain for those two pieces of property runs, Mr. Chang's reference 6 foot, onto the western side of his eastern property line.
I have that. I have that information, and that's an easement may exist. I can't make a finding unless I see other evidence other than recollections. And you understand why that would be. We don't draw property lines based on, well, I think it's here, oh, I think it's there. But there may be, and that's what you'd like to be utilized for mitigation of any impacts. All right? Okay. The city may have some other questions for your witnesses. Mr. Richardson?
Just for a matter of record, Mr. Cheng, can you tell me where you were licensed as a civil engineer?
State of Washington.
Okay. And is there a reason that you stamped the survey shots with your Nevada license?
Oh, well, when we look at the proposed plan here, you have an existing elevation at this corner of the house, proposed house. It says 40. It's very clear right here.
No, he's not asking. He's just asking about the stamp.
I'm asking questions to establish that you're a licensed civil engineer, which has been the claim of the appellant. So, and the license that you stamped the exhibit with was an expired Nevada license. So as long as it's clear that you are a Washington engineer, that answers my question. So thank you.
Oh, well, here, you can hand this back. Do you want
that is the extent of my question. I just wanted to verify that. That is all. No, I appreciate it. Thank you.
Okay, the city may have other questions for the appellant. Do you? No? Is the applicant representative, Mr. Shepard, do you have any questions for the appellant based on the testimony and exhibits they referenced during this hearing?
I do have at least one question, possibly more. I would like to look at Exhibit E4. And I would like to look at, within E4, it's a letter from January of 2009, but on the second page of that letter, the fourth point says, the fact that the proposed solution to the stormwater, groundwater, erosion control, and landslide stabilization of the site is based on the access and use of a fictitious 8-inch drain on our property. There are no easements running the length of our east property line. So I've been confused by this because I guess this whole engineering that we've done was based on the idea that there was nothing available to tie into, which today's testimony seems to say, why didn't we try and tie into this thing? So I guess I'd like clarification from the appellant as to what the true situation is with regard to an easement and or drainage system that's already installed.
Okay, you're looking at E4.
Second page.
A letter to Mr. Bauer from Mr. Crawford. So, Mr. Crawford, you're probably the right one to respond to that.
And appropriately, that is a error. On east, that would be west.
Right.
That would,
Yeah, I think
east is totally wrong.
That's what I thought. But.
And in reference to that, the best laid plans of mice and men. But anyway, I'm just going to reference a quick statement. We decline permission for the new construction to use our drain system because our water system right now is maxed out. And it's not, it was presumed to be an 8-inch system. Mm-hmm. To my knowledge, at least on my property, they use 6-inch French drains. Brian Rice's property gets, knee-high water.
Well, and you went into that already. This is an opportunity for the applicant to ask clarifying questions about your testimony, and you just did that with reference to one question regarding E4, where you said it was a mistake that east should have said west, correct?
Yes, sir.
All right.
But also that the drain exists?
It's a private drain.
It's a private drain, but the easement, an easement does exist, you think?
Easement does exist.
This is
Okay.
Mr. Chang now responding, but this is in your recollection and opinion. I don't have a legal document that shows the
Correct.
existence.
We're just trying to clarify what actually is installed.
Okay.
Could we were not clear on whether or not you are a licensed engineer in the state of Washington? Or not?
He did show me his license. Do you want to see that?
Yes, please. Okay, thank you. I have another question on Exhibit E6. In the second paragraph that starts with "our main concern," the last sentence of that paragraph says also that the site plan, quote, "vegetated flow path," end quote, "would go uphill as submitted." And I think the vegetated flow path, everyone would be in agreement, does not flow uphill, and so I'm just wondering if that's another mistake.
Okay, and my copy is an unsigned copy, but it has the 4 appellant names. Mr. Crawford, do you respond to that?
This, if we reference this, let's see, let's go ahead and look at E15.
Well, is this in response? The question is...
I understand, but in order to more fully understand our confusion, that if we reference E15, we'll see the vegetated flow path, and that it would appear that it looks like it would go uphill in that we assumed that the water would directly flow into the southernmost portion of it. Arguably, it's acknowledged that if you had enough velocity, you could bring it around and bring it from the northern portion of the vegetated flow path. Again, an arguable point, but on first reference, the anomaly with the elevations that we established, this concerned the overall plan and execution of it.
Okay, is that, so that document that referenced by the applicant's representative, Mr. Shepard, E6, is dated in February 2015, and it's a statement signed by you and the other appellants that the vegetated flow path would go uphill as submitted. I think you explained that you came to that conclusion based on your review of E15. You came to that conclusion based on your review of E15, is that correct? And do you still believe that to be true today? You still believe that to be true? Is that still your statement, the vegetated flow path would go uphill?
Apparently.
Apparently.
As submitted. It did raise some confusion. But that's an obvious oversight on our part, in that it's not an intent to insult the applicants or their integrity. It's merely a statement of confusion as it was presented. And again, remember that E15 is a quarter this size as we received it. This E15 copy is blown up 200 times. Well, not that, I shouldn't say that. It's larger.
Okay, Mr. Shepard, any other questions for this appellant?
I think just one further question on Exhibit E13.
This is the appeal statement itself.
Correct. If we look at the first paragraph, we, the undersigned, And so the main thrust of this appeal seems to be this sentence in quotes about midway down the paragraph, which is our main concern is the additional surface water runoff silt onto adjoining properties into Sammamish River via old storm drainage system and the detrimental change to the drainage flow and additional storm drain surface water into the wetland areas. If the project reasonable use 2014-047 is approved. There seems to be some confusion about describing whether or not this easement exists, whether or not the pipe exists, which is why we engineered as if it didn't, because we didn't have clear consensus, or there was no consensus on whether or not there would be approved access to said easement or pipe. But additionally, within this statement, it talks about additional surface water runoff, silt into adjoining properties and into the Sammamish River. I'd like to point out that there is no additional water generated by this proposal. Additional water would mean that we're bringing water from someone else. What we're designing and what we're building is the same square footage of the lot.
And now you're segueing into your presentation or your response. I want to give you a chance to ask any additional questions. I think you started with that you have a question.
Oh, I'm sorry. Okay, so the question would be where is the additional water generated from that would cause the detrimental change? Like, where is the net increase in impact of surface water that this statement seems to suggest would be existing?
Mr. Crawford, do you have a response to that, or one of your witnesses, or maybe in one of the exhibits?
Brian Rice would like to comment on that.
Okay.
Mr. Chang, I assume as well. I'll be excused for a moment.
Okay,
The
Mr.
additional water that we noted is about 50% more water would drain off the property because the house foundation and drives displace the soil so it would not absorb, therefore driving an additional 50% runoff that is what is running off today.
Can we ask for clarification? This is Mr. Richardson speaking for the city. Were there calculations done to support that quantity that was quoted?
Well, the city's asked its questions. It wants to know, Mr. Rice, and you can choose to respond or not, did you use calculations to come up with 50%?
Simple math. I think I wrote it down this morning. I write that down. Bear with me one moment.
It was more than a guess, right? You used some measurements or some observation.
Simple calculations based off of the amount of square feet that the property is. I think the property is 11,000 square feet, something like that, factored in 4,000 square feet for the house, including soffits, foundation, and then another 2,000 square feet for driveway, based off of the overall square foot of the property, and it came to around 50%.
Okay, Mr. Shepard, do you have any follow-up to that question? You wanted to know from the appellant where do they believe the additional water comes from. Mr. Rice has answered from the impervious surface area that appears to cover about 50% of the property.
Yes, I've heard their response. I guess just to note that none of the math is familiar or makes sense based on that response.
Okay, and that's an opportunity we're going to give you next as the applicant and the city to respond to the appeal. So we're at a stage in the hearing where the appellant has been given an opportunity to present information in support of its allegations in the appeal, and the allegations, I think, have just been articulated by the quote that you put in your appeal. Additional runoff will damage adjoining properties. So, Mr. Crawford, do you feel you've been given an opportunity to present the information in support of your appeal? I don't want to in any way cut off that opportunity.
No. I mean, yes, I believe we've presented, looking at everyone here.
Well, here's what I'll do. It's just about noon now, and we're going to have to take a bit of a break and return to the hearing room to allow the city and the applicant to respond to your appeal. So I will give you one more opportunity after the lunch hour. If you feel that there's something you wanted to present but you didn't, we'll give you one more opportunity to do that. But you have presented, you've walked me through each exhibit, and you presented Mr. Rice, Mr. Chang, and yourself as witnesses. So that's in compliance with what you said you would do. So I'm not encouraging you to give any more information. I just want to make sure you feel like you've had a fair opportunity to present information. Okay? So we'll ask that after the lunch break, and then both the city and the applicant, are you going to present information in response to the appeal? The city is saying yes, we will. And with how many witnesses do you think? Just Mr. Richardson?
Just, yes.
Okay, Mr. Shepard, what do you think you want to do in terms of responding to the appeal?
We'll make a short response and have two witnesses give very brief testimony.
Okay, so if we return at 1 o'clock, is that a sufficient break? And then we'll move forward first with the city that's defending its decision, and then with the applicant's presentation.
Yes.
Very good. Okay. In recess until 1. Okay, good afternoon. We're going to go back on the record on the appeal of Crawford et al. Versus the City of Kenmore. We've had an opportunity for the appellant to present information to me through witnesses and exhibits in support of their allegations that the city failed to disclose significant adverse environmental impacts related to surface water drainage, and that then the city failed to put sufficient mitigation on the permit or on the MD&S itself. And now it's a chance for the city to respond by presenting your own witnesses and information to me, and then the applicant as well. You ready to go forward?
Yes, thank you. So as part of the land use application and SEPA review, the city has reviewed environmental and surface water requirements.
And this is Samantha Loyuk, who's the
Yes,
city
I'm
associate.
Samantha Loyuk for the City of Kenmore Assistant Planner.
Let's ask you to take the oath, if you would, please. And do you swear to tell truth and testimony you give today?
Yes.
Thank you. So you're beginning to inform us about the background of this DNS?
Yes. So as background information, a land use application for reasonable use exception was received by the city on December 10, 2014 to construct one single-family residence at 8236 Northeast 169th Street. The 17,760 square foot property is currently vacant and zoned R4, which is residential 4 dwelling units per acre. The property, as mentioned earlier, contains landslide and erosion hazard areas and a Class 2 wetland. These critical areas overwhelm the site, making it a complex property that cannot meet the City of Kenmore Municipal Code critical areas standards. In addition, the project exceeds the State Environmental Policy Act SEPA exemptions set forth in the WAC, Washington Administrative Code, Section 1911-800. As such, SEPA environmental...
The WAC, Section 19711?
Yes.
Okay, I heard 19711.
Yes.
And what was it that triggered the environmental review then?
The wetland.
The wetland area itself?
Yes. Mm-hmm. The SEPA environmental review was conducted concurrently with the reasonable use exception, RUE. Four identical comments were received from the appellants during the 21-day notice of application comment period, and the city considered and responded to each comment and passed along the comments to the applicant as well. Generally, comments received had concerns about surface water runoff and topographical information as previously mentioned in this hearing by the appellant.
So were you involved in the environmental review as a responsible official?
I am the planner on the project, so I reviewed it for environmental reviews, and it was signed, the SEPA DNS was signed by our SEPA official, Brian Hampson.
Okay, but are you personally aware then of what comments were received?
Yes.
Okay, and do you know, your testimony was those comments were taken into account.
Yes.
How were they taken into account? Was there any change in the threshold determination?
There was not a change in the determination, but the comments were forwarded on to the applicant to provide additional information as far as the topographical information. So a new geotech report was received, and the project was conditioned on that report so that the future building permit would comply with the updated topographical information.
Okay. So let me know where you're going to go with your response.
Okay.
Is that the information you're going to provide to me, is how the environmental review ended up with, I guess we don't call them conditions because it was a DNS, correct? No mitigation conditions were placed on the threshold determination itself. Or were there?
There were mitigation requirements as required through the reasonable use exception.
But we're here on an appeal of the threshold determination.
Correct.
And wouldn't you agree that only the applicant can appeal an application? So we're not looking at the reasonable use exception here today, just the DNS.
Okay.
Well, I'm asking if you would agree with that, because when I read your ordinances, it tells me that only the applicant can appeal a reasonable use exception.
I thought that we received 2 appeals.
You did, but your ordinances are very specific that only an applicant can appeal, and we spent the morning looking at the environmental review.
Correct.
So I hope that's your focus today
It is.
as you respond to the appeal. I only have jurisdiction to look at the appeal of the threshold determination, the one done under the State Environmental Policy Act. And I'm kind of looking for it now, and maybe you recall, I believe it is just a determination of non-significance.
Correct.
There are no conditions placed on that.
That's correct.
Okay. So when you refer to conditions, those might be relevant, but I want to know where those conditions are. And you referred to one just now. You may be getting into that later in your presentation, but you said a new geotech report was done, and it would be conditioned on compliance with that. So that's the kind of thing I'd want to see as part of your environmental review, and how that would be carried through on this,
Okay.
on this development proposal. So just to clarify, we're here only looking at the appeal of the threshold determination, and it's the city's opportunity to respond to what the appellants presented, which was information on how they believe that you did not review this proposal appropriately, particularly and only really with reference to the surface water.
Correct. So I was just providing background information, but I agree we should move forward towards the surface water concerns of the applicant.
Okay.
The project has demonstrated compliance with the 2009 King County Surface Water Design Manual that was adopted by the City of Kenmore. It's also important to note that the applicant actually exceeded the minimum requirements by providing a secondary retention trench.
Are you going to provide more information on that?
Yes.
Okay.
Yes. Zach Richardson, civil engineer for the City of Kenmore, can provide additional information regarding how the applicant has met and exceeded surface water requirements. So it is at this time that I'd like to call Zach Richardson, civil engineer for the city, as a witness.
Thank you. Were you previously put under oath?
No, I was not.
And please, at this time, do you swear to tell the truth in testimony you give today?
I do.
Thank you.
So it's kind of my understanding that
This
some
is
of the
Zach Richardson.
Yes, some of the surface water concerns come from a misunderstanding of the common enemy doctrine and how we treat stormwater. Stormwater is generally allowed to flow downhill, and in fact, it's required to maintain its natural drainage course. And so any given property is allowed to continue to discharge water in its natural course. They just have to mitigate for any additional flows created as a result of impervious surfaces. So they're allowed to maintain the natural drainage course. They just have to offset the volume of that additional surface water that was discussed from the additional impervious surfaces. The way the city code reads now, there is, you apply small site flow control BMPs for individual single-family homes like this, and the project has provided a dispersion trench, which is then backed up by a retention trench. And at this point, I would like to draw your attention to Exhibit B6, which is the same soils report that the appellant referenced earlier in their testimony. And if you turn that report to the very next page, page 7, you will find that there is a stormwater dispersion system section heading, and immediately under that it reads, our recommendations for the surface water stormwater surface dispersion system are shown on plate 3 attached here too. Stormwater to be disposed should be discharged through a distribution trench over which water is to overflow and a sheet flow over a vegetated path. And so while this same report does say that infiltration is not recommended, it does recommend the dispersion system. And that is exactly the dispersion system that you will find on Exhibit C5 on page 2. There's the detail of the dispersion system, and that will match plate 3 from that report of Exhibit B6. So they have actually provided exactly what that report recommended.
But isn't that curious? And you're the civil engineer for the city, correct? Mm-hmm. Because the appellant pointed out that the conclusion on the prior page is that it's the second sentence there. Mm-hmm. You're familiar with it. The subsurface condition of the site is not capable of supporting on-site infiltration to dispose stormwater into the ground by infiltration.
Correct. So dispersion and infiltration are two different things. Dispersion is designed where the trenches actually fill up with water and then spill out over the front edge. That front edge is level, so the water spreads out in a nice sheet flow rather than a channelized flow. And then it's allowed a vegetated flow path downstream of that spreading area. The idea is that that mimics the natural drainage course as closely as possible and allows for plant uptake and some water to infiltrate and percolate in the topsoils. And this is a common method of stormwater distribution.
How does it account for additional surface flow from impervious surface?
What it does is spread the water out and has it sheet flow in a nice thin layer across the landscaping. And that the idea is that that mimics exactly the way the natural condition would happen. Stormwater would fall to the ground and then flow downhill to the exact same spot that we're going to end up at. As long as you've spread it out nicely and you've given it enough path to flow through, then you've met the mitigation requirement, because that is going to mimic the natural pattern.
So then you agree then with the statement that infiltration is not really possible on the site?
It may be feasible, but so what they've actually done is provide a retention trench below the dispersion trench. So they aren't actually providing infiltration. It's the dispersion trench, which meets code alone, and then they've actually gone an additional step above by providing the second retention trench to try and collect anything which may possibly be exceeding the existing flows. So they've actually provided a dual system in addition to what the wetland itself would provide. So we believe that this system is above the current code. And this review was done on the understanding that an easement was not feasible for this property. We found that it's documented in the report that is Exhibit C14 on page 3, paragraph 3. The report states that attempts have been made to tie into the 6-inch ADS pipe extending the Sammamish River, but the adjacent neighbor is adversarial to the development and refuses to allow a pipe discharge to leave the site. And this is also documented in our staff report, which is Exhibit C1 on page 7, and that would be in finding 7D. we did note that there was an attempt made to get an easement and that was not a feasible option. So that generally our contention is that they have more than adequately met the code for mitigating for the new impervious surfaces.
Let's stop right there for a minute, because you've testified several times if it meets the code, it meets the code. But what specifically are you referring to when you say it meets the code? What is it, a code section, or do you mean stormwater manual generally? Can you give me more specifics on that?
So this is through KMC 1335 that we've adopted the 2009 King County Surface Water Design Manual, and Appendix C of that manual is specific to small site applications, for which this is one. And so it is compliant with the current KMC 1335 and the subsequently adopted stormwater manual.
And that's still a fairly general reference. Is there something in that Appendix C that gives a goal of compliance, or what management of storm or surface water must meet?
Yes, and they must provide there's a list that you go through as far as what's feasible on the site, and one of the options in that list is the basic dispersion trench, which they have utilized. There are specifics for the exact details and design methods in that document as well. The final details are all reviewed again at the building permit phase. This is more of a conceptual level review at this point.
Okay.
And I think I'll leave it at that. Unless you have any other questions.
I do. We heard the appellant's witness testify that in his rough calculation, and he wasn't pretending to be precise, but he mentioned about 50% of this property would become impervious surface with development of driveway and house. Do you agree with that? And if not, why not?
I don't believe I do. From the plans we have, we are showing that there's 3,159 square feet of new impervious planned on a site that is over 17,000 square feet. So I do not believe that's accurate.
17,000.
Is that a calculation that you would do to determine if the proposed development with its drainage plan meets the Appendix C of the King County Stormwater Manual?
That's actually a separate section of the code. Do you know what section that's in, development code? There's a separate zoning code which limits the amount of impervious surface you're allowed to have in each zoning type, and I believe for R5 it is 50%. R4, yeah, sorry, not R5, R4. 5%? Yeah, 55% is their threshold.
55% of lot area, but I ask a different question. I was asking if you would do a calculation of impervious surface and its contribution to additional stormwater runoff as part of your opinion that there is compliance with Appendix C.
Yes. Sorry, I understand the question now. Appendix C does provide guidance for how long the trench has to be based on the amount of square footage of impervious you have. And so as you increase impervious square footage, the trench lengthens to spread the flow out more. In addition, you can do some other things with lengthening the flow path if you get to higher volumes.
Okay, and do you know which methodology was used here for 3,159 square feet of impervious surface?
I can't quote the exact section it is in Appendix C, but it is it meets the requirements under basic dispersion is what it's referred to as.
But were you involved then in determining the length of the dispersion trench based on 3,159?
The applicant submitted the length, but I verified that it matches code, yes. And again, those final details will be re-reviewed at the building permit phase when we know the exact square footage.
Well, I have to say, as a decision maker on an environmental review challenge, that's a small comfort, because that says we're kicking it down the road and we'll figure it out then. And there may be some need for that as to exact details. But this is the heart of the appeal, is the appellant's claim that with the additional impervious surface, there would be additional surface water runoff off the property itself. And although you may do final calculations at a building permit stage, what we're looking at now is whether that allegation is true or not, and it depends in part on what the surface water drainage system or method would be. And your testimony is it's both dispersion and detention. And dispersion you're confident in because it would meet the Appendix C basic dispersion requirements. And what I'm asking you is, can you be specific about what those are? Maybe the applicant can. I think your response is that you reviewed the applicant's calculations and proposal and found that it met the code. Now, here's the question. Does meeting the code give you 100% confidence that there would be no surface water runoff from the development of this proposal?
The key word being additional. Again, there is going to be surface water off the site because there is currently. We're not 100% sure that we can say that there would be absolutely no additional discharge from the site, and that is why we went the extra step and had them provide the retention trench. So between those two additional steps, between the dispersion that meets the code and the additional retention trench, yes, I can say I'm pretty confident that there's not going to be additional surface water.
Pretty confident. Is that more than 50% confident?
Yes. Yes.
So again, though, about the goal of the drainage system, your testimony is to not increase the surface water runoff. Are there proposals there where you look at actually, can we decrease the rate of flow with a stormwater drainage system?
That is not what's required. There is the potential to look at it that way. If we approach it that way, that is not the way the code is written. Mm-hmm. And we actually do not object to them tying into the downstream system if that is feasible through an agreement with the adjacent property owner. That actually would meet the surface water code as well. So we don't necessarily object to that option. If it's still on the table, we were just led to believe that was not feasible.
And the point being there, it's not your obligation as a city to propose what system.
Correct.
Or impose what system. You're looking at what has been proposed by an applicant and determining if it is in compliance.
Correct.
Right. One more question for you is about the testimony you offered that said the applicant's doing more than is required. Mm-hmm. And I think you followed that up with not only would there be dispersion, but there would be a detention trench that might offer limited infiltration or even evaporation, depending upon the time duration of the water in the trench. Is it your opinion as a civil engineer that the two systems together might in fact reduce the amount of surface water, the rate of surface water flow off the site?
That would be my assumption, yes. I cannot say that without running some calculations with the utmost confidence, but that is generally, given my experience and my background, yeah, I would expect it to decrease.
So even though the goal of the stormwater manual is not to decrease, your belief and opinion is with the two systems, dispersion and then at least detention with maybe infiltration, that's the unknown. Is that true? The
amount of infiltration you'll get out of that trench is the unknown, but it's going to capture it at least.
Yeah, it captures, and if it does provide some opportunity or evaporation, depending upon seasonal fluctuation primarily, then you believe it could actually result in a decrease in that rate of flow.
Yes, I do.
Okay. Thank you. Did you have any more testimony you wanted to offer?
No.
Okay, then we'll turn back to you, who's kind of coordinating the city's response. Do you have any other city witnesses?
No.
Okay, so that then completes the city's response to the appellant's presentation.
Yes, thank you.
Thank you. I'll turn to the appellant, and we have Mr. Rice that would like to ask some questions of Mr. Richardson.
Thank you, sir. So regarding the retention trench, you stated that the impervious area is about 3,000 square feet. In the event that that 3,000 impervious spills over the trench, and there is additional water coming over that impervious due to the fact that the ground is saturated, and it fills up that trench, where does that water go? Once it spills over that trench, where does that water go?
So it'll spill out of the dispersion trench, flow down through the vegetated flow path into the retention trench. If the retention trench was also exceeded in capacity, it would continue to flow towards the wetland.
And where does it go from the wetland?
My understanding is that it utilizes a private system to get back out to the river.
Hence, therefore, flooding adjacent properties.
No, the view the city has is that any new water created from the impervious surface will be offset by these mitigation measures. The remaining water would be water that is currently flowing that direction and functioning in that exact same manner.
I state it again, when the system overflows, it will flood to the adjoining properties. Is that correct?
It will flow to the wetland.
Which is adjoining properties?
If the wetland overflows to the adjoining properties, yes.
Thank you. I have no further questions.
I'd like to ask a question.
Well, okay, Mr. Crawford, and I guess you two individuals, since you've been involved in the appellant, I don't want to have too many people asking cross-examined questions. So you're the other appellant that would like to ask questions?
If I may.
Okay, please proceed.
Admittedly, we're not experts by any stretch of the imagination, but from brief conversations with people, they say reference your critical area standards, and they basically they don't want you to change the topography, and you talked about you're not supposed to change the stream flow. Well, currently, if you examine the stream flow or the flow of the water now during a downburst like we had a couple of days ago, you'd notice the movement and how it, water finds its lowest point. It gravitates that way a little bit laterally. We know all the different hydrology, but you know the science and the math. But net, we're just talking about once a glass fills up with water, it's going over. And Mr. Rice's point was just that you're removing and changing the stream course, and net, you only have so much volume of water to retain. That water is going to be concentrated now in a little bit smaller area, scientifically designed and proposed, but yet now instead of the whole area draining into more of a common stream, it's concentrated in one spot.
Okay, and this is your chance to ask Mr. Richardson questions about his testimony.
Is that not correct?
It will be in a shorter amount of flow length, yes, but it will be more evenly distributed than it occurs naturally. So,
more evenly distributed, but in an increased volume, correct?
Well, above the flow path, yes. The code says that by the end of the flow path, no.
Thank you very much. And that's I'm confused as to your answer. If you'd like to explain more.
So the code concept is that the 25 feet, when it's spread out properly, which is why you change the sizing of the trench based on the amount of impervious you have, it's a matter of getting it spread out as properly as possible. Then once it's flown 25 feet, it's had an equal opportunity to infiltrate or to get natural plant uptake and to do the natural processes that it would have had if it was just running down channels on the property.
Again, my assertion is that you're concentrating more water volume in a controlled path that you believe, by calculations, will retain or absorb some of the additional flow rate, because now you've redirected it in a specific area. I'm just saying, do you agree that it's limited to the conditions of the soil and of our rain? I mean, eventually it's just going to go over. You're just going to have more concentration going over a smaller area. Is that not correct?
No, I don't think I would say that is correct. I understand what you're getting at, and it will be a shorter flow path, but the idea is that in shortening it, we also widen it out so that we are using an equivalent area or something similar to it. It may be slightly smaller, it may be slightly larger, but that is the way the code is written currently.
No, I understand. I appreciate your answer.
Okay, thank you, Mr. Richardson. Mr. Shepard, do you have some information you'd like to provide in response to the appellant's presentation?
No questions for Zach Richardson.
Okay, no questions. So then the next opportunity is for you to present any information in response to the appeal.
Okay, I'd like to call Rick Heide, who designed the drainage system, to give testimony. Yes. Hold on. This is the city one. All of them?
Good afternoon.
Good afternoon.
Please take the oath if you would.
I do.
Do you swear to tell truth in testimony you give?
I do.
Thank you. And your name for this record, please.
My name is Rick Heide.
Okay, and you may have what we call narrative testimony, that you've been here throughout the morning and listened to the presentation of the appeal, and it's your opportunity on behalf of the applicant to provide any response you'd like to that appeal.
I'll attempt to do that. It's been a rambling narrative,
And what is your role with the applicant?
I'm the engineer who prepared exhibits B1 and B2.
Okay.
So I am the civil engineer. I also happen to be the structural engineer involved in the debris wall and the construction of, or the engineering of the house as it's done later. So I've been involved in how we are proposing to develop the site.
Okay.
In following that discussion over drainage, I've been doing drainage for quite a while. I started with the 92 King County manual, and we're now up to the 2009 manual. I think there's a couple of things going on here. First of all, the statement was made from the Liu report, B6, that the site cannot infiltrate. The current site has shrub, blackberries, small alders, and the surface is and it's also steeply sloped. So there's little actual infiltration that goes on, primarily the water that hits the ground runs down to the wetland. So the proposal is to terrace the site. In terracing, that reduces the slope. It increases the flow path. It slows down the amount of water. And so I would agree with the city engineer that in the end, there's a good likelihood there will be less water flowing off-site than there is currently. As part of the review process with the city, let's see, my drainage plan is Exhibit B2. As part of that process, we actually went through and reduced the size of the impervious that was proposed. So the current value that the city engineer gave of 3,159 square feet, that's reduced from what our original proposal was. It's quite a bit less than what surrounding properties have. But in the interest of reducing the impact to this lot, that was done. Another statement was made that the design given in the Liu report, that's Exhibit B6.
You know, I want to ask about that impervious surface, looking at
Sure.
Exhibit B2. You have the lot coverage expressed as residence eaves.
I'm sorry?
Residence eaves, you see that 1,040.
1,040. Resident, yeah, that includes the entire roof, including the eaves of the...
Oh, I see. Okay.
So we're
that's
identifying that it's not the footprint.
That's the footprint plus the eaves.
Plus the eaves, that's correct.
Okay, so the size of the living area of the house is
Less.
less than that, or at least the footprint of the house.
Yes, that's
Two-story?
correct.
Two-story house?
Two-story. Is it two?
3-story.
Three-story. It's three-story in order to minimize the footprint and minimize the impervious.
Okay. And what is, then you also have broken out under lot coverage, the PGIS areas.
Yeah, PGIS. In addressing impervious, there are two types of impervious that we are concerned about. There's the roof area, and then we're concerned about driving surfaces, because driving surfaces obviously have the potential, and it's abbreviated by PGIS. It's pollution generating impervious surface.
I see.
And that's why that's broken out separately, because we need to address that to make sure that treatment is provided as required to mitigate any potential oil drips or something like that.
Okay, thank you.
So as I said, when I got involved in the project, it had already been through another attempt at permitting, and during that process, the ability to tie into any off-site drainage systems was established that was not an option.
Is that because nobody wanted you to?
They were actually very adversarial to the point that the neighbors didn't want the development at all, and that was their mechanism of preventing development, was to prevent access to the easement. During the testimony earlier, it was very unclear as to what easement space they were talking about, whether it was east or west of the line.
Right.
But a number of people have attempted to find an easement. Obviously, if we had access to an easement, then we would have made use of that. But we don't, and it appears the easement, if there is one, is to the east of our property line, and therefore that would require, as part of the city's requirement for us to demonstrate that we were not just establish what was there. I did a downstream analysis, which I believe is Exhibit 1. As part of that, I walked the system, starting from the wetland on the subject property, as it states in Exhibit B1.
When you say you walked the system, what do you mean by the system?
Well, the purpose of an off-site drainage analysis is to determine what the path that the water currently takes as it leaves the wetland on site. So, as much as possible, walking means physically I walk along the path that the water takes, documenting what's there and how it ultimately goes to a receiving water, which in this case is the Sammamish Slough.
Okay, so you did that. And what did you find any indication of an existing system?
I did. If you look at Exhibit B1, unfortunately you don't have the color pictures, but if you look at page 4, I've got some flag notes showing where the proposed house is. I then show where the first yard drain was that I found. It's at the corner of the property east of this property. It appeared that I didn't find any evidence of an 8-inch system. I found what appeared to be a 6-inch. Rather than a PVC system, it appeared to be an ABS system, which doesn't have the capacity that a PVC system would. Then it appeared there were yard drains in the yards as that line appeared to move to the north towards the Sammamish Slough. As I moved to the northern properties, there's a significant berm on that line, so I was not able to determine for sure, but I was able to go down a boat ramp to the east of that and walk along in the slough, which is public access, and found the outfall of that and provided a picture of that. Well, I documented what I saw as I went along, including that discharge into the slough.
It's a little, we'll see, actually, that's...
Okay, well, your testimony is it's a 6-inch pipe.
It appears to be a 6-inch pipe.
You could tell at the outfall.
I could tell.
And is
the outfall, it was kind of hard to get to, but it appeared to be a 6-inch at the outfall, and it appeared to be a 6-inch where it began.
Mm-hmm.
So,
and you heard the appellant's testimony that our existing system is over capacity. Did you hear that this morning?
I did hear that.
And is this the system that they would be referring to, the 6-inch pipe and
I believe
yard drains?
so, but they also made reference to an 8-inch PVC system, which would obviously have a lot higher capacity.
Let's just clarify this with Mr. Rice.
Yes. So when I installed this 8-inch, I personally dug the ditch and installed it 30 years ago. It runs across my property with just to drain my property and the downspouts from the roof. And it is an 8-inch ABS. It's like a corrugated 8-inch that serves my property only. And the outfall is in the Sammamish River.
So that's a different outfall than what was observed.
No, it's the same outfall. I ran it to the river 30 years ago, and it runs across my property. It's my system for my property.
Do you think this is the same outfall that was observed by Mr. Heidi then?
I believe so, because I ran it all the way to the river.
It's possible there could have been multiple out discharges at that location. That location was kind of overshadowed by rocks and vegetation. So I'm not disputing that there's some type of system. As part of the drainage analysis that was done, which was
Well, I guess the point you're making, Mr. Heidi, is that even if there is an existing system, since your client has not received authorization to tie into it, whether it's overcapacity or not becomes a moot point.
That's correct.
Yeah.
And as a result, we went to the code and to the Lou report to follow the law. Excuse me, I'm sorry.
So you would not tie into the existing system, but had to look for an alternative because of the inability to get access through easement or other method to any 6-inch or 8-inch pipe that may be in place.
Well, let me clarify. Just give me a sec.
That's what I was trying to do. I was vamping for a while there. Give you a minute to clear your throat.
As part of the determination, the code or the drainage manual allows different ways to address different drainages, obviously, because each case is unique. The preferable method is to discharge directly to a receiving water body that's large enough that the amount of water coming in doesn't impact it at all. That was the first discussion we had with the city. The city said you're within a quarter mile of the slough. We would prefer that you do direct discharge. That was the reason that tying into that pipe would have been a benefit. We wouldn't, the increase in flow would have gone down the pipe, and this amount of flow relative to the flow of the Sammamish River would not be known. Since we didn't have that option available to us, the next option is dealt with under the adopted King County manual. The King County manual breaks out different levels of impervious impacts. Less than 5,000 square feet of new impervious is treated as nuisance flow. I don't want to use that word. But a flow that it's recognized that it's a very small project. It can be dealt with primarily through best management practices. There's a number of best management practices listed in Appendix C. And in our case, we already had the recommendation of Lou, who was the geotech. His recommendation was that we use a dispersion trench. The dispersion trench is sized based on Lou's recommendation. Unfortunately, on this site, there's limited we've reduced the footprint as much as we can, and at the same time, there's very limited space to provide dispersion, which...
Where is that shown on B2 here?
I'm sorry? Where is
On
what
Exhibit
shown?
B2, where does it show dispersion trench? Do you identify that with some other term?
It's shown, if you look, the dispersion trench is right here. You see a storm drain line going to a, and then there's a 25-foot vegetated flow path. You see that?
Mm-hmm.
So the
Yes.
flow path goes from the dispersion trench to the retention trench. If you look at sheet 2,
Did I just miss the you don't label those as dispersion trench detention?
well, if you look at sheet 2,
Okay.
it's a detail of that system. So it's there's a fairly large blow-up of it, and it's labeled as a distribution trench because it's really it's a distribution trench, but at the same time we only have about 25 feet to put to disperse. So so we're distributing the flow in that trench. You can see in the section down below it, the trench is 24 inches wide and 36 inches deep. So it's fairly substantial location that water will be taken to through a perf pipe. The perf pipe will discharge into that trench. It's recognized that through the drainage design that there are a lot of areas here in Washington that aren't really conducive to infiltration, but at the same time we get a lot of infiltration. We can take the benefit of it, but it's not necessarily design conducive.
Right.
So this has become kind of the standard method in Western Washington for dealing with stormwater. We're going to get as much infiltration as we can, and the water that doesn't infiltrate overflows a level distance. One of the other things that's noted, it was specifically called out in the Liu report, was that that vegetated flow path will be graded down so that it will be 15% or less. So it will have a slower water path across it. In addition, it's going to be vegetated. The wetland consultant can give you better information on that further. But that vegetated flow path will do a much better job of uptake and retention than the lot is in its current condition, which is basically just blackberries and the water just runs. This vegetated flow path will actually retard and uptake the water.
Well, that's heavily dependent on the type of vegetation, correct?
That's correct, but as part of the development of the lot, scrub alders that are on it now, which tend to shade out any of the more dense undergrowth that does do that, will be taken out. And so as part of the project design, as part of meeting the critical areas regulations, this area will be specified to have plants that will do exactly what it's designed to do.
Doesn't an alder tree act as a detention device?
In a very limited amount. Unfortunately, alder trees, because of the way they grow very dense, and which shades out the understory completely. You do get some, the leaves, which unfortunately aren't there in the wintertime when we get most of our rain. But when it is there, the leaves hold up some of the water, which then evaporates, so some of that water doesn't get to the bottom. But the water that does get to the bottom essentially is running on the surface because there's very little.
No uptake?
There's very little uptake in the, because the understory is shaded out and you have very poor plant growth. But the wetland consultant could better address that.
All right. Well, thank you. You've described the system that your client intends to put in place.
Well, almost. But in addition, we're providing this retention trench, which is not a standard design feature. It's meant to mitigate the possibility that a 25-foot trench, I mean, we've reduced the amount of impervious, but this trench is going to be 3 feet wide and 5 feet deep, 25 feet long, filled with rock, and any water that doesn't infiltrate in the first trench, that isn't taken up by the vegetation in the overflow path, will then go into that trench, which will provide retention. At the same time, we'll be getting infiltration out of that trench. So we're actually providing these two structures along with the vegetated flow path to mitigate the new impervious, which in addition will have some terracing, so the slopes on the lot will actually be a little bit less.
Why is the retention trench designed to hold a larger volume than the distribution trench?
We are going way this is not required by King County design. We're doing this to mitigate and go an extra measure of reducing the amount of flow that peak-wise, the volume will still go down, but peak-wise, that would be seen downstream.
All right. And what happens then if the retention trench is infused with water to the point of overflowing?
Well, at that point, the water is going to flow exactly as it does now. Now, the water, we get a little bit of uptake off the alders, but the water that hits the ground, hits a steep slope, it's routed very quickly down into the wetland, and then it flows off-site. So, the developed will actually have two structures that the water will have to go through before it hits peak, which would be essentially the same flow that's going off-site now would be going off-site then.
Does your drainage analysis include any calculation of the ability of the wetland A to retain water?
No. No, we're required to keep water going to the wetland, but we're not allowed to use the wetland to detain water.
Okay. All right. Well, thank you. Any questions you had, Mr.
No questions for Rick.
The city or the appellant may have some questions for you, so stay there. None from the city. Does the appellant have any questions of this witness? Bryce.
Based on my previous cross for the city, what is the percentage of probability of outflow from the retention trench in regarding to Puget Sound storm? What is the percentage of probability that that trench will be compromised and water will go over it?
Could you define what you mean by compromise?
Compromise, breaching the banks of that trench. That is our concern, that the amount of water that comes off of that hill and the property is significant. And I've seen it roll off of that property like a river, and it floods my property because my 8-inch can't handle it. And I'm just concerned when that trench is compromised with water going over the top of it, what's the percentage of probability of a storm that it will get compromised and the water will go over and it'll flood the adjoining properties?
I still don't understand your question.
So in a typical Pacific Northwest storm during the winter, when the ground is saturated and it can't handle any more water and the trench is saturated and impervious.
Wait. Would you explain to me, you're mixing two things. You're telling me what's happening now. When it's
Okay, so
saturated,
let me
and all the water is running off. And it's going
let
down
me
into your
restate. When the property is saturated from the impervious areas of the property and the trench is filled up due to the fact that that is saturated, because this ground gets saturated during the winter, how much water do you think will go over the top of that trench?
I'm not required to do that. I'm designing in accordance with the design manuals that provide for what is a recognized ability to address the storms that we have in this area. So I think you're confusing two things, because on one hand, the case that you're talking about is when the ground is saturated, which it would get into in the current conditions, which means every drop that hits that site now goes off site. In the future, the drop that hits that site will go into the system, overflow, go into another system, and then go off site. So right now you're getting a direct off site, and in the future we're going to detain it twice, and then it's going to go off site. So I would say that you're actually in a better position than you are now.
So we could debate, dispute. I have no further questions. Thank you.
I would like to ask you a question, and my name's Matt Crawford, if that's permitted. On B2, and looking northward.
Hang on, let me get it open. Yes, sir.
In essence, between ridges, we're just talking concept.
Between?
Okay, between two high points of a side hill, it creates a ravine, a small watershed, correct? A drainage basin.
Okay.
Okay. Now, if we look at you look at the map, and basically we have on the west side.
Well, we would look at sheet 1 if we wanted to
B2,
identify.
B2.
But you want to talk about a basin.
Well, we are talking about a basin.
But that's identified on B1.
Pardon me?
But we would look at B1.
Of the whole basin. No, I was just, I wanted.
Sheet 1 of B2.
Yes, sir. I'm sorry.
Okay.
But anyway, basically we're concerned with an area that comprises more than just the lot itself, in the sense that all water is drained into that basin. And that's what we've been looking at for years. And the water that comes there now, a good example is in C, what is it? C15. There are some better pictures of some of the spot. Pardon me?
What is
Exhibit C15 of the city?
Photos of current conditions.
Yes, sir.
This witness, I think, has been on the property, correct?
Yes, I have.
All right. So you can do that even hypothetically. There's water on the property.
Oh, yeah. Anyway, but anyway, our concern is that to be able to mitigate any additional water, I'm sorry that your interpretation of our refusal, our denial of you tying into my drainage, that inversely, or I mean, downstream goes into Brian's, and through our discussion and the fact that his water line rises to the point that his sump turns on, that we weren't ready to try to have an additional house on our system. Now, that apparently Mr. Yo Chang says that there is a easement down his line, that there could be a trench dug. When I looked at this property thinking of building, I offered way less money because I saw that there was a problem with the water and frightened of the mitigation and as the problems grew. But I wasn't aware of the time that there is apparently, I doubt Mr. Chang would make that up, a 6-foot easement on his side of his property down to the water.
Well,
it's an obvious solution.
Let me stop, because my client has done quite an extensive search to find that easement, and it's not been found legally. And so to now start bringing that up when it's been discussed since before 2010 as not existing, and we are not required to tie into any system. We're required to mitigate our water. We're allowed to do that by providing a dispersal trench. We're doing that. In addition to that, we're providing a secondary retention trench. So as far as the code is concerned, we're in compliance. We've done everything that the code requires, and we've done more than that. So the amount of water leaving our site should be the same or less than now leaves the site. So it sounds to me like you, as a neighborhood, have a water problem, and you might investigate redoing this private system to address all of your problems.
Well, in the sense that
I want to remind everyone here that this is an appeal of a threshold determination.
Yes, sir.
Where the city said there's no significant adverse impact, and you disagreed and filed an appeal saying no, there will be a significant adverse impact from water. Okay, so I don't really want to debate too much about neighborhood systems. All right. So it's your chance. We're going to ask him questions about his testimony.
Yes, and on B2, there's a retention wall above the structure, south of the structure.
I'm sorry?
On B2, page 1.
I'm on B2.
Yeah.
Could you point out what you're talking about, please?
I see it. It's a retaining wall. You must be familiar. That's just south of the house.
Pust residential drainage plan is a easy one to see. It's nice and big, but we've replicated it many times.
Other page. The first page.
Sir.
Sorry, he was talking about. No? You're on B1. Okay.
Yes, sir.
Thank you. Sorry. Okay.
Well, that cut on, well, the arch of your proposed retaining wall system appears to cause a barrier, and or as will the foundation of the proposed building, and dam and change the course of the current flow of the water. Our concern is, and to the adjoining properties, that water will be forced in an unrestricted manner, in a new manner, that are unknowns. And this has been our concern. In the big picture, it's been cause for restraint as far as my interest in building it and attacking this problem, I'll be honest with you. But nonetheless, it's a valid concern, and I respectfully I respectfully understand that with all good intent, but we've seen so many unusual water events in our particular neighborhood, notwithstanding, erosion events and landslides, that it's just, we're apprehensive. And to mitigate like in kind, treat your water like everybody else treats their water, and not add any additional water to adjoining properties is what we're really, again.
Okay, we're here to ask, it's your opportunity to ask questions.
I'm sorry.
Will the retaining wall and/or the foundation of the house alter the course of surface water runoff?
No, the purpose for this being shown was a condition regarding mitigation of the landslide hazard area. It was not part of the drainage system.
Understood, but
Any
I think Mr.
no.
Crawford's question, would it impact the surface water drainage? The fact of
The design of
placing
the
a
wall
foundation.
normally would take the drainage. It would not divert it off to the sides because that would be putting it where it doesn't belong. We would take the water and the water would be taken down to the natural discharge location. That would be addressed as part of the detailed permit plans. These were conceptual to show that we could mitigate all of the concerns related.
A retaining wall, if not, I don't know what the height of this wall is, but assuming it needs a permit, the retaining wall ordinarily would have to allow for water flow.
Absolutely.
Otherwise, it would fail.
Absolutely.
Okay. So it's your testimony that the retaining wall, I'm trying to get to your question here, would not divert water around it, but would allow flow through it by design.
Yes.
Okay. Is that what you're trying to get to?
Yes, that in the down or the northern portion of the foundation would substantially change the current course of the water flow, in that is not, I mean, it's a dam, and because of the nature of the fill that's required to re-terrace this property or this building, the moment slabs required for that would be substantial in the sense of the footing design requirements. And
So
that,
would the foundation itself act as a restriction to water flow?
that is in the form of my question.
Well, I think if you look at the profile on sheet 2, there's a cross-section through the hill.
I'm sorry, I don't mean to appear to be adversarial, but I believe that you're not acknowledging my question.
I am. I'm trying to address your question. You're saying that we're going to address the hill, and I'm trying to point out the way we've shown it is that the relative slope of the hill is going to be maintained under the building so that the seepage that's coming through there will not get dammed off by the building, but instead it will be it'll be built on top of.
Your soils reference report, is it not state that you have you're building on impervious soil?
We're not building, we're talking about two different things. Impervious soil is talking about drainage, about the surface soils. The foundation will be founded on bearing soils, which are below which. Okay, so
Is a barrier correct? Is a barrier? It's hard pan. It's hard sand. That's what the soils report indicates. That it's
yes.
impervious. It doesn't drain. It doesn't drain. It doesn't soak up water.
Right.
So
it doesn't now,
that is,
and it won't later.
Isn't that the preferred ground to anchor a dam? Yes or no?
We're not talking about a dam.
My question was, isn't impervious ground the preferred condition to anchor a dam?
I don't design dams. I'm sorry.
Okay, you don't know the answer to that question. Are there any other questions?
would you recognize that a impervious structure settled or set into another impervious structure, in other words, concrete, into hard pan sand, which is located on most likely this property and adjacent properties, is impervious to water movement underneath it, underneath the foundation?
And that's why subsurface drainage is provided around those walls,
Around the walls.
so that the water gets picked up and it gets placed back to where it would have gone when it was.
Before.
Yes, that's correct.
Before it was, the drainage was dammed or altered, correct?
Impacted.
Impacted. So I take that as an affirmative answer as to being dammed, changed,
I'm really
altered?
sorry, but you're trying to tell me what to say, and
Let me
that's not
step
the way
in
I'm gonna
because
answer.
I don't really want to
Okay,
continue
you're
to
right.
hear an argument.
Excuse me.
The purpose of the hearing is for me to gain information and not to determine who's winning an argument. The way I heard the testimony is that, yes, a foundation can impact the surface water flow, but I think the answer, by reference to B1 Sheet 2, is that there would be a provision for that by providing drains under and around the foundation
that's correct.
to return the water flow to where it would naturally go. Does that help, Mr. Crawford?
Yes, sir.
Okay. Did you have any other witnesses you wanted to present?
I had one other thing that I wanted to
Quickly? Okay.
quickly. Yeah, believe me, I plan to be out this morning too. The exhibit that they provided, the exhibit 16.
What topic are you referencing?
Their claim that our topography was not correct.
Yes, yeah, that's an exhibit, E16, I believe.
I did get that late last night, so I looked at it last night, and I don't have a copy yet. Oh, here it is. E15, is that what? Yeah. Real quickly.
Yeah, E15 is where the appellant showed, with reference to an item J, that there was a indication of a 10-foot difference in Mr. Crawford's backyard property, and his testimony is that that must be an error because it's level from
That's
what he can
correct.
see.
And I wanted to point out that this was a topography map that was prepared for the subject property, not the adjacent properties. And I'm sorry, give me a second. So I took the rod shots that they gave last night, or that they gave to us that I got last night, and I applied them to the
What exhibit do you want to list this one?
Well, this... If we allow this in, this would be, we're going to mark this as B9.
So I plotted the line that they had given us. Sorry, I'm trying to find my original. And I converted their rod shots to elevations, and I would like to point out at 75 feet out, which is about as far out as you would expect, there's a 75 which crosses the 30 contour. At that point, their rod shot was 30.16, and a normal contour map is within the accuracy of half the contour interval. So this contour map is a 5-foot contour interval. We would expect plus or minus 2.5 feet. So what their evidence shows is that, in fact, our 30 contour is exactly where it should be. As you go further off-site, as I said, that was estimated because they didn't survey off the site, so anything past the property line is an estimation. The other thing that I would like to point out is that if there was some concern about the flow direction of our trenches and flow path, that a survey would have been done in that direction, and it wasn't. So I just wanted to point that out, that in spite of the late getting the information, that
So your testimony is you agree with the appellant that the indications of a 10-foot drop are estimations and are not the result of, as you refer to them, rod shots,
yes,
because you had no access to that property
that's correct.
and no intent to survey that property because you
correct.
were looking at the site proposed for development.
I further went on to King County's website and obtained their topography of this area, and I don't know if you want to see it, but it is well within the 2.5-foot interval, and it also shows that 10-foot. It's very difficult to estimate where there's a lot of trees and stuff, and so
Okay.
I just wanted to give that testimony.
So there seems to be agreement that that 10-foot difference is an estimation on the map that was prepared by Mr. Heidi, and did not intend that to mean that it was an accurate representation. Mr. Crawford?
Yes, I would like to submit, though, that perpendicular westward from that point is the west from along our grade point where we cite J at 40.
Hang on.
And that's a 10. If you follow that contour line into your into the subject property, that would follow then that is 40, and that is absolutely not correct.
No, that's not a correct train of thought.
Pardon me?
We wouldn't follow it onto the property. The topography was most likely shot along the edge of the property, and what goes off the property is estimated.
No. To the west of J is onto the subject property, and that is in a ravine.
I think his answer is you're moving the line the other way. The estimation is in error because you've moved from the subject property off-site. But if you start off-site, you can't move on-site.
And then assume if it's wrong on my property and it drops lower on their property, it doesn't get higher. It's not 40 here. It's certainly not 40, 20, 30 feet away.
I don't have any data for that.
Well, nor do I, but all I'm saying
Okay.
is that if we have an anomaly.
Is there any
Okay,
other
I
thing?
think we've reached the stopping point for this witness. Thank you, sir, for being here and offering your testimony. Do you have another witness, Mr. Shepherd?
Couple brief questions for Mr. Rothwell, who designed the mitigation plan
Okay.
for the wetland.
Good afternoon.
Good afternoon.
And do you swear to tell truth in testimony you give today?
I do.
Thank you. And your name, please, for the record.
My name is Jim Rothwell.
And I think you want him to give narrative testimony as well? Or do you
Jim
have
can give
questions?
narrative testimony, or there's a couple questions. Jim, do you have a preference? I mean, I'd like to hear about the mitigation plan, a little bit about the monitoring, and about just the method of design
Sure.
of the proposition.
Sure. Yeah, so I am the wetland ecologist that was hired to do the wetland delineation and develop the mitigation plan. The goal, my main concern is maintaining the hydrology of the wetland and replacing any impacted buffer or wetland areas. Since the majority of the property is encumbered by buffer and steep slope areas, we're, obviously this is a reasonable use hearing. We had to do mitigation, trying to replace the impacted buffer area by enhancing existing buffer, enhancing the wetland, and then enhancing and planting the flow path. And I don't know how much detail you want me to.
What are you
get into,
doing for mitigation? What is the mitigation?
So there's a few things. The first thing, we're doing a standard buffer enhancement area, which is at the north. It's actually at the north end of the property, and then kind of intermingled between the flow path and the wetland. A lot of those areas right now are dominated by Himalayan blackberry, which is an invasive species. So that's going to be removed and then replanted with native upland species and buffer species. Then we're doing wetland enhancement and planting native wetland plants in there. Right now, the wetland contains a mixture of reed canary grass, some alder, and other herbaceous species, and then also some blackberry, which is invasive. And so we'll be enhancing that with more native vegetation. We're planting the flow path, again, with plants that are suited to wet or moist areas, and that will assist with any water flowing through that area, helping to slow it and disperse it.
How's that? Why don't you give me some detail on those plants? So what's there now, and what do you think is going to help with uptake? That was the testimony of your other witness, that there'll be measurable uptake from plants that you've selected or will select to put in the vegetated flow path.
Right. The plants that I spec'd for that area, dogwood, ninebark, and twinberry. Those are three species of shrubs that are their preferable habitat is in wet or moist areas. So that's where they typically thrive. They're not only limited to those areas, but that's where they do best. As far as a measurable quantity of uptake, I don't know how to. There's no way to really to determine that.
Are you a landscape architect?
No, I'm a wetland ecologist.
A wetland ecologist.
Yeah.
So you're able to identify plants that indicate a wetland area.
Correct.
Called hydrophytic vegetation.
Right.
But you're not so familiar with selecting plants that take water up. But isn't there a body of scientific literature on plants that are used, less so in this country, but certainly throughout Britain, that are intended actually to serve as alternatives for a septic system? You've seen reference
yes.
to that.
Oh, absolutely. And that is done in this country as well sometimes. But
Okay.
there have been numerous studies done for, yeah.
So you're familiar with those?
Correct.
Wouldn't those be appropriate if we're trying to get some transpiration, I think would be the word, of water in this vegetated flow area?
Yes and no. The majority of those, at least from the studies that I've seen, the majority of plants that they use for uptake for water treatment concerns are things like cattail and other herbaceous species that need constant flooded areas, constantly wet. That's not the situation we're going to have here in that vegetated flow path. It's, I mean, I'm expecting it to be wet sometimes, but not permanently ponded or
We'd have to
such.
add water to the site.
Right, there'll be water. I mean, there's water flowing through that area anyway, in that path. So, right.
All right, so that's your intent, is to use what might be closer to wetland vegetation, or like you said, dogwood or some shrubbery.
There were three species specified for that area.
Can you say those again?
Sure. So red osier dogwood is one, Pacific ninebark is the other one, and black twinberry. But I can also say that dogwood and twinberry are also found on areas that are a little bit dry. There's dogwood on the site already now outside of the wetland area, so it is capable of growing in both wet and somewhat non-wet conditions.
Do you have any questions for your witness?
The only question I have is in regards to the monitoring. Now, there is a monitoring plan in place with this?
Correct.
And can you just speak briefly about that, timeframes? I mean, this is all information everyone has. The cost of that, just briefly, that this is not just installed and walked away from, but it's...
Right. So per the Kenmore Code, 5-year monitoring plan is required, and that involves, I think we specified 2 visits per year. Let's see. Okay, sorry. Annual visits. It depends on the site. Sometimes we'll do annual or semi-annual. So annual visits to check on the site. See how the vegetation's doing, and there are specific performance standards that the planting areas need to meet in order to be deemed successful at the end of the 5 years. So, for example, the first performance standard is at the end of year 1, there needs to be 100% survival of vegetation, and then that drops each year, and by the 5th year, there needs to be at least 70% survival. And then I think we have a cover standard, also aerial coverage of the vegetation. Needs to meet 20% aerial coverage at the end of the 3rd year, and then 40% at the end of the 5th monitoring year. So, invasive species need to be below a certain point. 25% is what we expect. So yeah, so there's there's 5 years worth of a monitoring report is prepared each year and then submitted to the city. And then if the mitigation isn't meeting these performance standards, then there's contingency measures that are taken.
Okay, thank you. I don't have any further questions.
Okay, thank you for your testimony. Do you have any questions of this witness, Mr. Crawford or Mr. Rice?
In reference, Matt Crawford speaking, in reference to your delineation of the wetland area, what time of year did you make your assessment, or how many times did you visit the site to make this assessment?
Sure. So I visited the site 3 separate times. The actual delineation was performed during my first visit, which was April 2014. I think it was actually April 1st. I went back to the site in June of that year just to take some additional data, see the site again, see if it was still saturated. And then a 3rd visit was performed this past February, and that's when I went back to use our GPS unit to pick up the flags, since that portion of the site wasn't getting surveyed. So,
have you ever walked the toe of the slope or the bottom of the ravine?
By the
stream course or the lowest spot?
Going down to the slough, you mean? Or
No, from the lowest spot on the of the property up through the low spot in the ravine, or I mean, I don't know how to. I call it the toe of the draw.
Yeah, I walked the entire property from 169th all the way down. That's what we have to do when we do a delineation. But the only other areas, I walked down the driveway a bit just to follow the ditch and see what happened. We're not really allowed to go off-site unless we have approval, you know.
Well, thank you.
Yeah.
Okay, thank you for your testimony today. City, have some comment?
Yes, thank you. It'll be pretty quick. In
No,
your
that's
critical area report, which is Exhibit C15, page 7, you say the proposed mitigation plan will protect and enhance the functions and values of the wetland and buffer. The city determined through the SEPA determination of non-significance, after we reviewed all the materials on the environmental checklist, I'm getting to the question. We determined that there would not be an adverse impact on the environment. And as a senior ecologist, would you agree with that determination?
Yes, I would. Yeah.
Thank you. That's all the questions I had.
One more question.
Mr. Crawford?
On your visits, did you take note of the evidence of landslide, and particularly the tilting of different trees uphill and downhill?
I didn't observe any landslide areas on the site. I'm trying to think back to the site now. There was no. I didn't see anything. I'm not a geologist by training, but I know what you're asking.
I'm just talking about. There's one particular large. It's not a cotton. It's an alder that's about 8 years ago, and then it's going straight now. You know what I mean? So
curved, something like that.
Curves uphill, and some of them move down. Typical of some movement.
Of landslide.
You know, when the tip of the tree crowns vertical.
Right.
But anyway.
I don't recall seeing any of it. No. I have been on sites where there's a lot of activity and you'll see no vegetation at all, but yeah. So. Good.
Thank you.
Okay. Yeah, you bet.
Does that complete the applicant's presentation?
Yes, it does. There's only one other thing of note, is that I didn't submit this as evidence, but the lot is being taxed as having value as a buildable lot. So that is the tax status of the lot.
Mm-hmm. Very good. Okay. We're at the point where we've completed presentation of appellant's case and then responses to that case by the city and the applicant. There is an opportunity, if you'd like to take it, for a brief closing statement. Your choice. Would you like to make one? Anyone on behalf of the appellant?
Mr. Rice?
Does the city have any closing statement you'd like to make?
No, I think we've said what we've needed to.
Okay. Applicant? No. Okay. Mr. Rice would like to
first of all, I'd
sum
like
up
to
things.
Thank you, sir, everybody else for participating, providing time for all of us to gather here today. Obviously, a plethora of data and information has been provided. I understand the mitigations. I just hope that we're not gathered here in the next year in a situation where we're talking about what are we going to do in regards to surface water runoff flooding the adjacent properties. So that's our main concern. That's why we're here. We're talking about families, millions of dollars of properties, not just water, millions of dollars of properties, probably $10 million worth of properties we're talking about here. And this is just not a nit to our community. It's significant, and I'd hope that you look at that in regards to everything that's been discussed today. It's a big deal. Otherwise, I wouldn't be here. So thank you for your time.
Okay.
Appreciate everyone's involvement.
We would like to make a closing statement. Bob has talked to me. I think we just want to say that, you know, everyone else has their properties there. The Pusts have owned this property. It's being taxed as a buildable lot. There's a process in place for lots like this. It's called reasonable use. The exhibits submitted by the applicant are entirely and concisely representative of the main points of science and engineering that support all of the exhibit list that was submitted by the city as a review of that process, and that our intention is to actually improve the situation and not to make it worse by any stretch of the imagination. That's all.
Thank you. Well, I now have a job to do, and I take it seriously. And I know that the appellants, it's not your preference to be in a formal hearing about environmental impacts and mitigation, but it is the course that you needed to follow to express your concerns about the proposed development. And you went to a lot of effort to prepare exhibits and then present them to me today. I think you may have a new appreciation for attorneys and what they do, because it's not easy to present the material, but you did so, and you got through it this morning. And the city attentively has listened, I think, throughout this process and provided a response. And as often occurs through these appeal hearings, you as appellants were alleging that the city made some mistakes and didn't do things right. And what often happens is you present information, it comes to light more clearly about what is the status and what was done by the city. And the city often hears, as they did today, they were very curious about the existence of an easement. So sometimes appeal hearings can clarify and help things move along with more clarity of expectations and what should happen if development goes forward. And I'm convinced the applicant, represented here today by Mr. Shepard, is sincere about complying with the elements of the code and hasn't given me any indication that they're treating this in any way as anything other than a serious appeal, and are concerned, too, about compliance, not only for legal reasons, but for preservation of any building that might occur on the property. Those codes are in place for a reason, and that's to not only protect surrounding properties, but also to allow development to occur without causing damage to the site itself. So I'm aware of all of that. I've listened very carefully now for several hours, and my job is to make specific findings. I appreciate the help you gave me in making those findings. I was making notes throughout the hearing, and I'll do those findings, and then I reference those to the laws that we talked about today, and then ultimately I need to decide if the city properly performed its responsibilities under the State Environmental Policy Act and has properly mitigated any impacts that there might be below the level of significant. And along with Mr. Rice, I hope, too, that we don't see this in a year. What I do hope we see is if the development goes forward, and I'm not tipping my hand here, I'm just expressing along the lines that you're opened up, that there is perhaps a neighborhood coming together, because it's the kind of thing that can tear a neighborhood apart. But you've unified around this, and hopefully you'll be able to continue to move forward as a neighborhood, looking at a quality neighborhood. So that's what we're hoping, all of us. All right, it's long enough, 2:45, and we are now adjourned.
Thank you.
Thank you.
I will register the copy so that I can have it. I'll bring it right back.
Thank you.
Okay.
You have everything else, right?
Yes, I do. You know how to shut it off?
I mean, it appears to be
Sorry.
Just start yanking, huh?
Yeah.